Members, if you could take your seat, please. Clerk, please open the roll. Members indicate your presence. We have a quorum, and the Criminal Law Subcommittee of the House Courts of Justice Committee will come to order. And while we have a docket here, it's pretty much in numerical order, which means there's not a strong logic. So I do not see any major groups of individuals that might be waiting to testify on a given bill. So with that, I'm going to go ahead. While I didn't see which members came in first on the list, help me, So let's go with HB 320. Cole.
Thank you, Madam Chair, members of the committee. Before you is HB 320. It specifically bans live streaming to social media while driving. And I want to stress what HB 320 does not do, because there's already laws to address these issues. It does not ban Zoom calls while driving. It does not ban FaceTiming while driving. It does not ban backup cameras, security cameras, or dash cameras, and it has nothing to do with holding your phone, texting, or watching the screen. There's already laws addressed to do that. It is a secondary offense, meaning live streaming to social media while driving will not be grounds to initiate a traffic stop. And HB 320 has specific carve-outs, including allowance of live streaming while driving in cases of an emergency, or if you are experiencing or watching something unfold in live time. This bill does also allow warrantless searches. An LEO must get a warrant to conduct a search of a cell phone. This bill puts into code a real and growing issue: live streamers live streaming themselves while operating a motor vehicle, interacting with an audience in real time. There have been real accidents, real injuries, and real deaths because of live streaming while driving to social media. I think that's the bill that I have before you, Madam Chair, and I hope it will be the privilege of the body to pass it to full.
Thank you very much, Delegate Cole. Are there questions or concerns from the members? Seeing none, we can then go directly to taking testimony. Are there people here who would like to speak in favor of HB 320? Is there anyone here speaking in opposition to 320? I have online speaking for Kristen Petway from Drive Smart, Virginia. Kristen?
Madam Chair, members of the committee, thank you to Delegate Cole for this legislation. And I don't think I have to explain how dangerous live streaming while driving is, but I just also want to point out that live streaming while driving glorifies dangerous driving, and we don't want to be promoting that, and we want to give police and law enforcement the tools they need to address this issue. So thank you, we do support this.
And seeing no one else wishing to testify, our typical procedure here is to first ask of attorneys, are there any concerns that you might wish to bring to our attention?
Just briefly, Madam Chair, the issue that I had brought up was concerns about proof of how it would be proven, the police, that someone was live streaming while driving. Just oftentimes people will start their phones once they're pulled over and interacting with the police. And so I just had some concerns about police officers seizing phones if they see people live streaming once they're pulled over, because it's not a primary offense. And although the statute protects against warrantless searches, which is already established under Riley v. California, what about warrantless seizures of phones to try to prove that people were live streaming while driving is, I guess, the concern that I had.
Madam Chair, we did hear testimony from state police during transportation. I don't know, I think they're supposed to be here today, perhaps, maybe. But
Madam Chairman,
Please
of the
proceed.
subcommittee, I'm Kent Shipman with the Virginia State Police. Though State Police has no position on this bill, I'm here. I wasn't the person that was here the first time, but I can try to answer some of the technical questions that you may have.
Thank you. If I may ask one question, it's my understanding that we already have a prohibition on warrantless searches of phones if you were to confiscate one as part of enforcing this bill before us. Is that true?
You would be able to, I guess, if you were afraid that evidence is going to be destroyed on the phone, you could seize it with the intention of obtaining the search warrant. But normally, you're right, you would try to get the search warrant first.
So you could not go further than us, other than to document the use of the phone as far as the offense that you have.
What we're talking about now, the way it's written, that is correct.
Thank you. I see on those who have said, I hope I have this in the right order. I believe Delegate Davis indicated he wishes to speak first.
Thank you, Madam Chair. I have a question for legal. What are the, this could also be potentially reckless driving, correct?
That's correct. Certainly, reckless driving forbids certain speeds, but then also reckless driving generally if the person is operating the vehicle in a way that was, had reckless disregard for human life. So whether that could be distracted driving, texting while driving, live streaming while driving. Yeah.
Thank you.
Thank you, Delegate Delaney.
Thank you, Madam Chair. So this bill did come before Transportation, which I'm also on, and so appreciate Delegate Cole's second visit on this bill. And I, as Chair of Transportation, did suggest that it come before us in court simply because there were some questions surrounding, if I recall, this being a secondary offense and how that would work in the process of collecting the evidence and the warrant, but to also just make sure we're clear on the type of behavior that the delegate is kind of getting at, that these are often young people who are kind of doing online pranks and live streaming, so it's not just, live streaming yourself getting pulled over or a road rage incident or something and wanting to kind of collect that which is happening, which I think the delegate has put those types of provisions in. This is trying to get at a behavior that people are kind of using their platforms as a way to get online attention by doing pranks and different behaviors with their car for social media and causing harm. But again, kind of pulling it back to why some of the questions that were raised in the Transportation Committee that I felt were a bit out of the scope of that committee and more appropriate here, largely went around it being a secondary offense, and just if council could kind of address the mechanism for it to be discovered and this law to be applied in that case.
Well, Madam Chair, I mean, I can take, Madam Chair, Delegate Delaney, I can take the first part. So because this isn't a secondary, this would only be a secondary offense. If an officer saw you driving on the road and you were doing this, they can't pull you over for it. So you would have to be doing something else, maybe speeding, maybe not using a turn signal, maybe blowing through a stoplight, depending on which provisions of those also have the not a primary offense code section that we added a couple years ago throughout the code. So that is where Ms. Paul's was kind of coming from with the enforcement would be difficult because once your car is stopped, if you then turn it on, you would not be breaking any laws because the law says you can't have any handheld phones, and then when you're parked, you can use your phone. So that would be a difficult of enforcement at that point.
Follow-up question, Madam Chair. So the live streaming itself in this case would be a secondary offense. They wouldn't be able to pull you over if they saw you doing it. However, you may be and likely would be violating other primary offenses while doing this, such as, it could be you holding your phone or just reckless driving in general, and then this would be kind of a layer upon that if the evidence made itself available, whether that be that the live stream was online and available to see, or if they were able to collect that evidence. And I guess that was kind of the part with, the primary offense may result in them being pulled over. They notice that the live stream has also been happening, and then I guess kind of fill in that gap of that's now secondary. They've noticed that it's happening. How do they kind of collect that evidence to have it be admissible?
Sure. So a primary offense is to hold your phone while driving, so the police can pull you over for that. Obviously, if someone wasn't holding it but had it positioned up here, they couldn't be pulled over. You wouldn't know necessarily that someone was live streaming while driving, but it is illegal to hold your phone while driving. There's a mandatory fine on a first offense, and on subsequent offense, I think it's $125 for a first, $250 for a second, and that is a primary offense. I guess the concern or question I had with regard to proof is, unless it's plainly obvious that the person, when the police approach, is live streaming, and even then they wouldn't know if they were necessarily doing it while driving. Although, yes, you cannot search a phone without a search warrant. That is the law. You also typically can't seize personal effects without a search warrant. So the concern would be, would this result in seizures of personal property to hold it, as the member of the state police said, to get a search warrant to get evidence? So unless it's plainly obvious they're live streaming, they would have to then do some sort of investigation, either get consent for a seizure or seize the phone, because you don't just need a search warrant to search a phone, you also need it to seize a phone unless it's plainly obvious that it's evidence of a crime. So I just want to be clear that we need warrants to seize property just like we need them to search, unless there's an exception, if that makes sense.
The next, Delegate Williams.
Yes, Madam Chair. A question for council.
Please.
How does the last sentence in paragraph D play out? Because it just says that a court may order the driver not to drive. And I'm wondering, is this an offense? How is this? What is this? What's this violation?
So it's equivalent to like the same thing as a license suspension. So I guess what they're saying is if they don't have a Virginia license, they can order them not to drive pursuant to like an out-of-state license, or they're unlicensed. But if you're unlicensed, you already can't drive. So, it would just be a violation of a court order if they got caught doing that. But it could also be other things, like if they're unlicensed, driving no OL, driving without a license, or if the ability to obtain a license in Virginia was suspended, driving on a suspended license.
Madam Chair, could I have a follow-up?
Please.
So if it ends up being a court order, is that going to move it into contempt, or is it still going to leave it under this particular code section?
It could be contempt, or if the court suspended the fine, it could be kind of like a violation of a court order that they could get that fine, because it's not a criminal. Yeah.
The next, I also have Delegate Schmidt. Delegate Schmidt.
Thank you, Madam Chair. I also have just a clarifying question for council. I notice in paragraph B, it says while driving a moving motor vehicle. Is that there so that once the vehicle is stopped, you can continue to, or you can, what I'm trying to wonder about is that, we have cases where people are stopped by police. They want to start live streaming so that they're able to document for everyone. And
Right.
are they going to be able to do this, or will a police officer be able to tell them to quit filming because of the statute?
Well, and that was one of the concerns I had. Yes, I think based on the language, it means that if the vehicle is stopped, because it doesn't say operating, like for a DUI, operating could be just sitting in a car when it's running. This specifically says moving and driving, and both of those things has said, like, you're actually physically driving the car. The concern is, I guess, knowing the difference. If someone live streams the minute they're stopped, they're technically in compliance with the statute, but the police may investigate if someone's live streaming when the police approach, and then the question is, how do they prove it was occurring while driving, and then are we seizing people's phones based on that?
Well, I was just going to say, Madam Chair, one, there's already provision in here that talks about unless you're live streaming an emergency situation, or if you're streaming because you're pulled over. But also, when you stream to live social media, those videos are out there. They don't just disappear because you turn off the video. So those videos are going to be able to be found for evidence, and they can see when those videos were started.
Thank you, Delegate. I will follow up on the delegate's comment as I have processed all that's going. We can't solve all the problems of the world in one bill. But cumulatively, as I'm listening to all of these elements, if there really is the interference with driving that we are concerned that there will be, as that occurs, then you have possibility of offenses that would be reckless, or the provision which says if you're involved in an accident, this then becomes an element that you would look at in looking at the circumstances and the culpability of who was at fault in the accident, et cetera. So I'm looking at all of these elements that, well, just stopping someone from doing it is not what this bill is about, quite frankly, because it'd be incredibly hard to enforce just that. But I think as an element in all these answers, I'm increasingly comfortable as I listen to the dialogue.
And certainly, like, if someone caused an accident or killed someone and they were doing this, that could be involuntary manslaughter, reckless driving, all of those things would be taken into consideration.
Mm-hmm. Are there other comments or questions from the committee? You have the final word of the committee. Oh, I'm sorry. I see we have two more. Delegate Davis.
Madam Chair, question for the patron. Why not make this, I mean, this is very dangerous. Why not make it a primary offense so they can be pulled over immediately to prevent an accident?
Sure. Madam Chair, I would respond to the delegate because we were keeping in line with the laws that are already there, and I believe we moved certain things to secondary offense back in 2021 during that special session we were in, and so we put it in line with that.
Delegate Williams?
Yes, and I promise the patron that I'm not trying to hurt your bill. Question for the council.
Yes.
In line B, it does say moving motor vehicle. Is that going to reference to all the other motor vehicles that are in the code section? So it's not just a car, it could be a scooter or something like that?
Yeah, motor vehicle is defined by the other code. So it would be whatever motor vehicle is defined as, it would apply to that.
In the 46.2 section, I guess.
Yes.
Okay,
Yes.
Thank you.
Delegate Coulson.
Thank you, Chair Watts. Question for the patron or council? I guess what about viewing as well? Participate, like, I guess I just also still have some ongoing concerns. Your answer didn't provide much clarity for me because I can't imagine that while pulling someone over, the police is going to be able to access whatever live stream they think you were on and watch it and compare the timing and make sense of it there. And then I guess I don't think they could do this, but I just want to raise it. If we're saying something's illegal and there's video evidence of them doing this, is like after the fact, we're going to look at the live streams and be like, this person was driving, we can now go. I'm just curious what this looks like.
I mean, officers get summons after the fact if they, like if they see someone driving and then later determine, hey, I know that's Joe Smith, and then I run his record and see that his license is suspended, officers can go get a summons or warrant for driving unsuspended, not for this. This would be an infraction, so it could only be a summons. So technically, yes, they could go back and investigate. With regard to questions about access to these platforms, I mean, it depends if they would know their username and things like that. I mean, the police have different ways of investigating this stuff. A lot of officers will follow certain accounts, but if they don't know what account it was, I mean, they would have to do that investigation to find the video.
Seeing no one else wishing to speak, you have the final word.
Thank you, Madam Chair. I just want to underpoint the main thing is that there are a lot of things happening now with people streaming on social media specifically to show themselves racing cars. They're driving their car while doing other different videos while live streaming. And so this is just to make sure that we can have protections in place. It's already illegal to hold your phone. It's already illegal to watch certain videos while you're driving. I mean, in my car, I have a DVD player, and as long as I'm parked, I can see what's on the screen. But as soon as I put my car into park, it gives me a message that says, according to the laws of your jurisdiction, you're not permitted to watch this video while in drive. So those laws are already in place. This is specifically making sure that we can protect people when they are live streaming to social media while operating a car or motor vehicle.
Thank you. We operate by motion.
Move to report.
Do I hear a second? Been moved and seconded that we report HB 320. Any further discussion? Clerk, open the roll. Members, cast your vote. HB 320 reports, and it didn't have an amendment or substitute. It's as it came to us. Thank you. By a vote of 9-1.
Thank you, Madam Chair, members
Thank
of
you,
the committee.
Delegate Cole. Thank you. And now I see Delegate Adams has House Bill 317.
Good afternoon, Madam Chair, members of the subcommittee. First, I have a substitute, and I'm willing to explain it either before or after adoption. There should be printed copies.
It's been moved and seconded to adopt the substitute. Any discussion? All those in favor say aye.
Aye.
Opposed? Please proceed.
Thank you, Madam Chair. So the substitute you have before you for House Bill 317 accomplishes two things. Number one, it incorporates the spirit of HB 769, and that is with the blessing of Madam Leader Herring.
Pardon?
Make that motion to incorporate hearings.
I'm sorry, I was distracted. Excuse me. I am incorporating bill number.
Madam Chair, I'll make the motion. So I'm moving, and if the patron will make sure I got this right as well. I'm going to move to incorporate House Bill 769 into House Bill 317.
Thank you. It's been moved and seconded that we incorporate HB 769 into 317. All those in favor say aye.
Aye.
Opposed? Thank you.
Thank you, Madam Chair. Thank you, Subcommittee. So the substitute for my House Bill 317, which now incorporates House Bill 769, is the Senate cognate to SB 743. And Madam Chair, HB 317 strengthens Virginia's protections of critical infrastructure. These are the essential systems that keep our communities functioning every day. Across the Commonwealth, facilities that deliver electricity, water, broadband, sewer, and other core utilities are increasingly targeted for intentional damage and disruption. When these systems are attacked, the consequences are immediate: service outages, public safety risks, and serious economic harm to our localities and businesses. This legislation updates and clarifies our criminal code to ensure that intentional destruction or damage to critical infrastructure, including the technology systems that operate it, carries appropriate and consistent penalties. Importantly, Madam Chair, the bill preserves proportionality. Minor repairable damage remains a misdemeanor, but when someone deliberately targets infrastructure that serves the public, particularly systems that could endanger lives or large populations, the law will reflect the seriousness of that act. Madam Chair, I respectfully ask for the subcommittee support, and I know there are some people here representing the different utilities and industries that are referenced, so I will answer the questions I can, and I will defer to them when they are more technical.
Are there any questions of the patron or any comments? Seeing no one wishing to speak, I will open the floor then for individuals who are here to speak in favor of HB 317.
Good afternoon, Madam Chair, members of the committee. I'm Ray Lemure, President of the Broadband Association. I'd like to also highlight that this issue was brought before the Broadband Advisory Council. It was unanimously endorsed. We have spent, and the Commonwealth has spent, billions of dollars investing in broadband. This simply is removing telegraph, some old language, and updating the current code. So I'll be glad to answer any specific questions you may have. We're not changing any felonies or any penalties, just updating the linguistics of technology today.
Thank you. Please all come forward. I see you have a total of 3 minutes if you could now set it on the clock. Thank you.
Thank you, Madam Chair, members of the subcommittee. I'm Chloe Hodges speaking on behalf of Virginia Broadband Cooperatives today. I want to thank Delegate Pope Adams as well as Delegate Herring for working on this bill and carrying this important code update. It's really important to us that we're protecting our critical broadband infrastructure. We support the bill. Thank you.
Seeing no one else wishing to speak, then is there anyone in the room wishing to speak in opposition to 317? Seeing no one, and we have no one online, we're back to the patron. Any comments from council? All's fine. We operate by motion. Oh, you have the final word.
Oh, thank you, Madam Chair. Just final word, as a rural Virginian who just recently got broadband, I just want to do everything in my power to make sure our system stays intact. Thank you.
Move to
That's
report.
a good final word. Well done.
Yeah, move to report with substitute.
It's been moved and seconded that we report HB 317 with substitute. Any further discussion? Open the roll. All those, please cast your vote. And HB 317 reports with substitute unanimously by a vote of 10-0. And I'm just saying, for those who haven't followed Crim Sub before, even though it has a fiscal impact it is part of what we call the icebox bill, that the Budget Committee says that this committee in our wisdom has struggled to decide which bills are in good shape and are most needed, and we have X amount of funding from the budget, so it will go directly to the floor rather than having to go through the budget process. So you are the first one out of the block. Congratulations,
Thank you, Madam Chair.
The next patron who is here, Carla, excuse me. Thank you for keeping track of who's arrived. Please, and your bill number is HB 295.
Okay, I have two, Madam Chair, and I'll start with 295.
Okay.
Thank you. Thank you, Madam Chair and members of the subcommittee. HB 295 makes a focused but important clarification to Virginia's aggravated murder statute to ensure the men and women serving inside our correctional facilities are clearly recognized within the law. Current statute already provides enhanced recognition when certain public servants are deliberately targeted for performing official duties. They include law enforcement officers, judges, fire marshals, police powers, and witnesses involved in criminal proceedings. These provisions reflect a longstanding principle in Virginia law. When violence is directed at those responsible for carrying out the justice system, the impact reaches beyond the individual victim and affect the safety and stability of the entire system. Corrections officers perform that same public safety mission every day. They maintain order inside secure facilities, supervise individuals in custody, and operate in environments where risks are real and tensions can rise quickly. HB 295 ensures the statute clearly reflects their role by explicitly including the willful, deliberate, and premeditated killing of a correctional officer when committed to interfere with the performance of official duties within the aggravated murder definition. This legislation was introduced following the loss of Corrections Officer Jeremy Hall, whom we adjourned on the floor today in honor and memory of. It was a tragedy that reminded us all of the dangers corrections officers face each day. But the broader purpose of this bill is about strengthening the safety and stability of our correctional system as a whole moving forward. Safe and stable facilities benefit everyone inside of them. When officers are supported, recruitment and retention improve, staffing levels stabilize, which has been a problem, and facilities are better positioned to deliver consistent programming, maintain order, and create environments where rehab efforts succeed. That stability benefits not only officers and staff, but also the incarcerated individuals who live there every day. HB 295 is about statutory clarity, equal recognition for corrections officers, and supporting safer, more stable correctional facilities across the Commonwealth. I respectfully ask for the committee's support and happy to answer any questions.
Thank you very much. My basic question is to turn to council. Is there an amendment? The question was raised as to whether or not correctional officers in the context of this bill also includes officers for jails and regional jails.
Madam Chair, members of the subcommittee, so when you look at the subdivision A6 as a whole, the first line says a law enforcement officer as defined in 9.1-101. That is a very long definition, but it does apply to your typical law enforcement officers, and typically in your local jails, they are staffed by the sheriff's office. So it would cover them. I'm unsure if it would cover a private police department or private jail. I'm unsure about that part. And it does look like the definition of law enforcement officer also includes employees with internal investigation authority from the DOC or by the DJJ pursuant to relevant law. But it does not look like it would cover in that specific subdivision all of those employees.
Thank you. I appreciate the extent of your answer. I really don't want to grow the Christmas tree that much. So I do appreciate, though, that we are in public correctional officers at all levels. I appreciate that completeness. Are there any other questions? Seeing no one wishing to be recognized, do we have anyone in the audience who would like to speak in favor of HB 295?
Madam Chair, if I may, I have a couple Commonwealth's attorneys from my district that were unable to get signed up correctly, but they were in support of this bill.
Thank you. Is there anyone here speaking in opposition to 295? And we have no one who wishing to speak. So you have the final. Is there anything else from council that we need to? You have the final word.
Obviously, Madam Chair, this legislation came from a tragedy that happened within my district, and I think corrections officers were left out, and I believe they should be included in this code personally, and respectfully ask for your support.
It's been moved and seconded that we report HB 295. Is there any comment? I'm going to make one comment before we vote. I really try not to bring up my checkered history, but way back when, and we just started Valor Awards, I was so proud that the first Valor Award recognized a correctional officer, that the rest of law enforcement understood the situation that they were under. So I commend you for bringing this forward. With that comment, seeing no one else wishing to speak, clerk, please open the roll. Members, cast your vote. HB 295 is reported without any further amendments, unanimously by a vote of 10-0. Thank you very much, Delegate.
Thank you. I also have.
And you have one more.
You want to go with 294?
Mm-hmm.
Yep. All right.
I don't know. This is Crim Sub. Yes, please proceed.
I don't want to push my luck, Madam Chair, but thank you. Before you is HB 294. This is also a correctional bill inside our correctional facilities. Safety depends on stability, like I spoke to on 295. We count on these officers to show up every day and keep order in places that can turn unpredictable very quickly. And when a corrections officer is intentionally attacked, it doesn't just affect that one officer. Housing units can be locked down for months sometimes. Programs stop, medical movement slows, and the disruptions felt by everyone inside the facility, including the inmates who depend on these routines. We've seen that reality here in Virginia at River North Correctional Center, which is in my district, and also at Wallens Ridge. Corrections officers have suffered serious assaults while simply doing the jobs they were asked to do. Those incidents remind us of the risk the men and women face are real, and they in fact affect entire institutions when they occur. HB 294 makes a focus update to the section 18.2-51.1 of the Code of Virginia to ensure the law clearly reflects the responsibilities of corrections officers and treats them consistently with other public safety professionals already protected by statute. By strengthening the clarity of the law, we help support safer working conditions for the officers and also more stable environments inside the facilities. At the end of the day, stable facilities are safer facilities for the officers who work there and for the individuals housed there, and for the communities those individuals will one day return to. So I respectfully ask for your support of HB 294.
Thank you. Are there any questions of the patron? Yes, please, Delegate Mathen.
So I don't have a question, but I did want to just give a brief comment. I wanted to thank the patron for bringing this. My father was a correctional officer for many years, and it really just highlights the importance and the dangers of the work that they do. So thank you for that.
Thank you, Delegate.
Madam
Thank
Chair,
you for
just responding. Absolutely, and I believe corrections officers are often forgotten for the jobs they do. And this really just brought it to light to me about the situation that happened in my district.
Thank you. Is there anyone here speaking in favor of HB 294?
And
Anyone
Madam
here
Chair,
to speak on
also
that?
my Commonwealth's attorneys were supporting this bill as well.
Excellent. Anyone speaking against? And seeing no one online? Council, do you have any further comments? All right. Okay, final word.
I think we've about covered it all. I appreciate your support.
Second.
Moved and seconded, we report HB 294. Any further comment? Clerk, open the roll. Members, cast your vote. HB 294 reports unanimously by a vote of 10-0.
Thank you, Madam Chair and members of the subcommittee.
Thank you. And now I see we have, and I'm looking for the right number here. Thank you. Yes, so you also, Delegate Ballard, have two HB 99.
Yes, ma'am, Madam Chair. And I will say I was impressed from the freshman delegate, two unanimous bills out of Crim Sub. That's pretty good.
Yeah.
So if you like, Madam Chair, I can start with HB 99. This is pretty straightforward. This was brought to me by a constituent who's a Christiansburg police officer. And I won't go into the details. He was going to sign up and speak online or be here, but something happened and he couldn't. But this kind of came out of a officer-involved pursuit back home, and he had this idea to change this code section, the 46.2817. And really all it does is it makes a mandatory minimum term of 1 year confinement for this felony eluding crime if during sentencing these things are proven. So it's pretty straightforward in its concept. I think at the end of the day, Madam Chair, it's just going to be a policy decision on whether or not this committee wants to report it out, adding that mandatory minimum of 1 year into that code section.
Okay, so it is a Class 6 felony and a mandatory minimum.
Correct. So under subsection B, basically, if for the felony eluding, the Class 6 felony, as you said, Madam Chair, and it says the next sentence that was added, such person shall be subject to a mandatory minimum term of confinement of 1 year in a state correctional facility if evidence is presented at sentencing that the law enforcement officer or the agency used equipment. And the way he explained it to me, Madam Chair, members of the committee, he was talking about spike strips. And it's not just limited to the spike strips, but it could be like your pit technique or your boxing techniques where they're engaged in some type of technique that has to forcibly stop the vehicle. And so that's a very dangerous situation for other motorists on the road. It's a dangerous situation for the law enforcement officers involved. And so in recognizing that danger to the public and to the officers, it's added in that mandatory minimum of 1 year.
Thank you. Delegate Williams?
Yes, question for the patron. It looks like for Section B, they've got to meet all of those issues like willful and wanton disregard of the signal and things like that. And then the provision that you added were the aggravating factors if they had to do a pit maneuver and stuff like that. So they have to be guilty of the original Class 6 felony, and then this bumps it up.
Yeah, Madam Chair, Delegate Williams, I mean, that's exactly right. So it's not changing the code section of how you prove that offense. All this is doing is it's saying at sentencing to get to the mandatory minimum of 1 year, law enforcement, well, it'd be the Commonwealth Attorney, would have to prove those things at sentencing to trigger that mandatory minimum. But it's not changing elements of the crime. It's not changing anything in that code section. It's just adding that mandatory minimum if, again, spike strips or some other forcible technique was used to stop the vehicle.
Thank you. Are there further? Yes, I see Delegate Schmidt.
Thank you, Madam Chair. I have a question for perhaps the patron or legal. It says on line 24, where the responding law enforcement agency used equipment, including spike strips, what else are we talking about here with, when we say the definition, or we put in there that if they are using equipment, what is that? And what does it entail?
Yep.
Anything?
Well, Madam Chair, Delegate Schmidt, a really good question. I thought the same thing when I read that. And I can defer to council as to what would be included in equipment. I think that would be incumbent upon the law enforcement agency or the Commonwealth Attorney at the sentencing of it to show that this equipment that was used to forcibly stop the vehicle. Again, the way the officer explained it to me, what he was getting at was spike strips that you would put out in the roadway to stop the vehicle, or this box technique where you pull up beside the vehicle, and it's usually used at slower speeds, and you kind of box in the vehicle and force it to a stop. Other equipment, I can't really answer that for you. I was hoping he would be here. He could speak to that. And maybe council knows the answer. I certainly don't know what would be included in the definition of equipment. But if this committee is hung up on the potential expansiveness of the word equipment, I'm certainly happy to amend it to pare it down to spike strips or pit techniques or box techniques.
Madam Chair, before we go down that road, I'll just, speaking to the bill briefly, I'm not a fan of mandatory minimums. So I don't think you have to correct the equipment language for me, because I don't think I'm going to be supporting the bill, because I'm just generally I'm opposed to mandatory minimums. So don't wordsmith it on my part. If anybody else wants to wordsmith it, that's fine.
Thank you. If I could follow up on this line of questioning before recognizing Williamson, Cousins, and Colson in line. My follow-up is that I look also then with the or, such motor vehicles used to intentionally damage the law enforcement vehicle. So that could be any degree of damage in stopping the vehicle, no matter what the police enforcement vehicle was. Just if you hit the police enforcement vehicle, it's a mandatory minimum.
If it's the way it's worded, if the judge were to find that at sentencing, then yes, they would be bound by the mandatory minimum.
Thank you. Delegate Cousins.
Thank you, Madam Chair. I just have a question for the patron or counsel. So these seem to be, are these factors that a judge can already consider at sentencing to make a sentencing decision?
Madam Chair, Delegate Cousins, I would say yes. The only difference with the amendment to this code section is when the judge is considering these factors, then the mandatory minimum could be triggered. Without that, there is no mandatory minimum.
Yeah.
So, but yes, I think the judge could consider those factors, certainly.
Okay, so I have a follow-up question. So I guess why is the mandatory minimum necessary here if a judge can already consider these as aggravating factors during the sentencing?
Madam Chair, Delegate Cousins, so I don't practice a lot of criminal law. I'm more personal injury, and counsel can certainly correct me if I'm wrong, but there'll be sentencing guidelines that's put together, and so the judges kind of have to keep it middle of the road with the sentencing guidelines, and without the mandatory minimum in there, oftentimes in these cases, it's going to be well below the 1-year threshold for the punishment. And so adding that mandatory minimum recognizes the danger in what's going on when you have to forcibly stop the vehicle, and so that person is going to serve a year in jail.
Thank you. Seeing no one else wish to speak, I'm going to first ask for, is there anyone here in the audience who wishes to speak in behalf of HB 99? Anyone here in opposition?
Madam Chair, Rob Hogan-Class, Justice for Virginia. We oppose mandatory minimums. They don't work. They don't deter crime. They take discretion away from judges. We're asking the judge in these cases to consider all these factors and make all these decisions, but when it comes down to punishment, we're stripping them of any ability to judge a case based on its facts and circumstances. We're saying, we trust you, judge, to make this decision and this decision and this decision and this decision, but when it comes to punishment, we got it. We know what's best. We're not going to listen to the facts. We're just going to categorically say this is what this person gets and screw your decision making. And so for that reason, we oppose mandatory minimums and we oppose the bill. Thank you.
Thank you. Seeing no one else in the room and also no one online, before I give you the last word, Council, do you have anything to add to this discussion? Concerns to raise?
Yes, thank you, Madam Chair. And just going along with what Delegate Cousins asked, yes, the court at sentencing considers any relevant information that's presented. So if the Commonwealth chooses to present this information, which I'm sure they would because it's the facts and circumstances of the felony elude, the court can consider that and should consider that. The difference here is if these things are met, the court shall. It doesn't say may, it says shall give them a year. The patron is right. There are sentencing guidelines. Those are not mandatory. The judge can go above if they find aggravating factors and they have to state why, or go below. I can say from experience, if the defendant has any sort of criminal record, usually even misdemeanors, the felony elude guidelines usually start at a year. So it's usually within those guidelines. But again, this would make it so that the judge had to give a year.
All right, you have the final word.
Thank you, Madam Chair, and I appreciate that from council. I mean, that's exactly right. That's the way I understand it. And I'm not here to try to change your mind about mandatory minimums. I think at the end of the day, it's a policy decision from this committee whether you want to change this code section to add that mandatory minimum. Again, this was a bill brought to me by a police officer in my district, so I'm happy to carry it for him, but I'm not going to try to change your mind on mandatory minimums.
Thank you. Okay. It's been moved and seconded that we report.
Substitute motion that we lay this bill on the table.
Second.
Okay, substitute motion is to pass by? Table. Table. Substitute motion is to table HB 99. Any further discussion? Clerk, please open the roll. Members, cast your vote. HB 99 is tabled by a vote of 7-3. Thank you. And you have another.
Yes, ma'am, Madam Chair. Thank you. So the last one I have for the committee today is House Bill 102. And this was brought to me by a constituent who serves as an assistant Commonwealth attorney for the city of Radford. And she's here today. She's my technical expert for this. And I'll just kind of say a few things to tee it up for her. But in short, this bill addresses the imbalance in the penalty structure for voluntary manslaughter. And so as this committee, I'm sure, is aware, voluntary manslaughter is the intentional killing of another person and is punished as a Class 5 felony. Class 5 felony is 1 to 10 years incarceration. So if you compare that to the crime of involuntary manslaughter, which is the unintentional killing of another person, that's also punished as a Class 5 felony, and again, it's 1 to 10 years incarceration. So what this bill does, it makes voluntary manslaughter an unclassified felony, and that changes the penalty range to 1 to 20 years incarceration. And I was a little bit surprised to learn when I was kind of preparing for this bill is that many of the felony property crimes in the code, and I'm sure counsel can correct me if I'm wrong, they're unclassified felonies, again, with a penalty range of 1 to 20. So on the one hand, in the code, we're saying if the intentional killing of another person, you could get 1 to 10, but if you have grand larceny, you could have 1 to 20. And so that just doesn't make a lot of sense. And that's what this bill is designed to do, is it addresses the disparity in the code that currently felony property crimes seem to be punished far more severely than the intentional killing of a human being. And with that, Madam Chair, I'm happy to try to answer any questions, and I do have the Assistant Commonwealth Attorney who drove 4 hours to be here, so I'm glad she made it.
What I'm going to do, since I see no one wishing to speak, your phone a friend, if your Commonwealth Attorney could come forward and share the perspective.
Good evening, Madam Chair, members of the subcommittee. So my name is Nicole Cumberland, and I am an assistant in Radford City. House Bill 102, thankfully, does not have any mandatory minimums, does not have any, it gives full discretion to the judges, and that is the purpose of this bill. As many times we have a situation that brings us situations or issues to light, and that's exactly what happened. I prosecuted a case in the New River Valley. The defendant intentionally stabbed a woman over 30 times. The victim obviously died from those injuries. The defendant had a very extensive criminal history, including convictions of burglary, abduction, but for trial purposes, that's not relevant. At sentencing, the guidelines were run for this individual. His guidelines recommended a range 9 years, 9 months to 17 years. And our judge only had 10 years possible to give him. And as it was stated, as I dug into this and saw that many other states in the United States have a difference between voluntary and involuntary in their penalty structure. Further, that the Commonwealth of Virginia, we do have property crimes that have up to 20 years. It felt that it was an appropriate amendment to bring to you all, and I appreciate, hopefully, your support and consideration.
Thank you. Are there any questions of the
Chair. Madam Chair.
Council, is there anything that you might add? Yes. I'm sorry. I see Delegate Schmidt.
Sorry, I just had a question for the witness, if I may, Madam Chair.
Please proceed.
Yeah, sorry. Yeah, I had a question about the case you brought up. So that person was charged with voluntary manslaughter?
No, sir. So it was a second-degree murder. It would be there were drugs involved from victim and defendant, and the jury convicted of voluntary manslaughter. As stated, the prior criminal history, abduction, protective order violations don't come in at trial for a fair trial purposes. But when it came to time to sentence, it does not feel that there is an appropriate discretion available to the judge or the court to sentence in that situation. So this does not change the low end at all. It actually, if a conviction for voluntary manslaughter occurs, I mean, a judge has discretion just to give a fine. It's actually a fine or up to 12 months and then the maximum of 20 years. So it doesn't change a low possibility at all.
Thank you.
Thank you.
Okay, thank you. Seeing no one else wishing to speak, let us turn then to those who wish to speak in favor of 102. Please come forward. You have 2 minutes.
Good evening, Madam Chair. Derek Davis, Commonwealth's Attorney for Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. We do support this bill. As they've already stated, it brings the penalties more in line with the harm that's caused by these actions. The perfect example is the grand larceny offense. 20-year maximum penalty for stealing someone, 10-year maximum for killing that person. Again, and these conversations are very hard to have with loved ones who have lost someone, and you're trying to explain to them that the maximum this person can get for killing their loved one is 10 years. Thank you.
Is there anyone else here wishing to speak in opposition to 102?
Madam Chair, Rob Hogan-Class, Justice for Virginia. Agree with the patron and his witness on one point, which is that our punishment for grand larceny is incredibly out of line. 0 to 20 years. I don't know of a single person in the Commonwealth of Virginia, happy to be proven wrong, but I don't know of a single person who's ever gotten 20 years for grand larceny. That punishment should have been reduced a long time ago, but we're talking about ratcheting the system the other way because we have this pre-existing punishment that is ridiculous. So, we oppose the bill and hope that you will too. Thank you.
Thank you. Seeing no one else wish to speak, and Counsel, you've already commented. Would you like to share other thoughts with us?
I just want to clarify for everyone that voluntary manslaughter is an intentional killing, but it's done in the heat of passion, upon adequate provocation, or in mutual combat. It is a killing without malice, so it is not the same as second-degree murder or first-degree murder. And just in commenting on what the Assistant Commonwealth Attorney said, is what we often see is I've had one case where a client was actually charged with, from the beginning, voluntary manslaughter, and everyone agreed that he was being robbed at gunpoint when he killed someone else. The witness for the Commonwealth testified, we are robbing him, but the guy that got killed didn't have a gun. He was acquitted because our defense was self-defense. That's the only time I've ever had a client actually charged from the jump with voluntary. Most of the time, they're going to be charged by the Commonwealth with first-degree murder or second. And then voluntary is usually when a defendant has a legitimate self-defense claim and they go to jury and the jury doesn't know what to do. So voluntary is one person says it was self-defense and the Commonwealth believes it was premeditated first-degree murder. And we get voluntary, which kind of is not a win for anyone, but kind of a win for everyone. Or we get voluntary when commonwealths make that offer because a defendant does not want to go to trial on first-degree murder and risk 20 to life, but a commonwealth realizes they have some problems with their case and a defendant can kind of suck up a maximum of 10 years. So we very rarely see people actually charged with voluntary. It's usually the result of a plea agreement or a jury verdict. And then just with regard to the guidelines, the reason sometimes voluntary manslaughter guidelines go above the 10-year is because that worksheet considers all types of murder, so also first degree and second degree, which first degree carries life, second degree carries 40. So I have had situations where someone was convicted of attempted murder and they had a bad record and their guidelines were above the max, but that's because that worksheet also includes murder. So just for explanation.
If I can follow up on that sharing, is one of the reasons that they don't charge voluntary because it's a maximum of 10 rather than 20?
I think the reason is because most of the time there aren't witnesses who are willing to come to court and say this was in the heat of passion or a struggle. Usually voluntary is when a defendant argues self-defense. So they're charging first degree because they believe it was premeditated, but a defendant is saying, no, I acted in self-defense. I thought they had a weapon. It's very rare that the facts are going to be for voluntary. Like I said, the one case I had was in the course of a robbery and everyone agreed and the Commonwealth's own witness was saying, yes, we were robbing him at gunpoint, but the guy he killed didn't have a gun. But our client was like, I thought he did because the other guy did. So that would be adequate provocation. A robbery, everybody agreed that that was adequate provocation. He just said he was in fear for his life and that's why he shot.
Delegate Schmidt.
Thank you, Madam Chair. Another question for council. Are there other mitigating factors that could possibly be brought in as evidence to bring it down from first degree, second degree murder to voluntary manslaughter? Or are we generally just talking about self-defense?
I mean, if it's in the course of a fight and everybody agrees that, that would be voluntary. There's case law about like if you're punching someone and beating them up, but it's not enough to be, I was in fear of harm to the point of death or serious bodily injury, then your overreaction in killing someone besides just punching them back would be voluntary. That would be adequate provocation or mutual combat. But most of the cases that we see, a defendant saying it was self-defense and the Commonwealth saying it wasn't. But yeah, in the course of a fight and someone dies, that could be voluntary manslaughter. Could be involuntary too, it just depends on the facts and circumstances.
I'm going to do another follow-up. The word malicious, what is the case law on what malicious means?
Well, malice is essentially doing something with ill will. So malice is pretty easy to prove, and there's also case law about you can presume malice with the deliberate use of a deadly weapon. So yes, that's how malice is defined. Essentially, ill will. Heat of passion is lack of malice in that you didn't have the time to stop and think and do it with an ill will because it was in the course of a struggle or a mutual combat or something like that. So if someone is hitting you and you pull out a gun and shoot them, that might be a lack of malice because you didn't have time to think or process or calm down.
Thank you. I see no one else wish to speak. I believe now, Delegate Ballard, you have the final word.
Thank you, Madam Chair, and I appreciate that discussion. I mean, that's the way I kind of remember it from law school. I think of voluntary manslaughter, your heat of passion crime is you walk in and your spouse is in bed with someone else. I think that maybe that's why they call it the heat of passion. And so there was no malice aforethought in committing that crime. On the other hand, when I think of involuntary manslaughter, I'm thinking like you're driving a vehicle and you're drunk and you smash into someone and you kill someone. You often will be charged with that involuntary manslaughter. And then to the charging decisions, I mean, I think counsel is correct. A lot of times the Commonwealth Attorney will charge high on a murder case and the jury will compromise and find them guilty of the voluntary manslaughter. I mean, that's a whole nother, I think, discussion. This is, the way I would view it, there's just a disparity in the code right now where you have voluntary and involuntary manslaughter. It carries the same punishment because they're classified the same. And so it's just trying to change that well, I guess, clarify or rectify that disparity in the code and make it an unclassified felony. And so I hope the committee will look favorably upon the bill and report it out to the full committee.
Thank you, Delegate Ballard. Delegate Williams?
Yes, Madam Chair, I wanted to speak to the bill. I just looked up real quick the other states and what their penalty ranges were, and it looks like Virginia is one of 10 that caps it at around 10 years, and everybody else seems to be above that, up to 20, up to life and stuff like that. So just giving that some perspective.
Move to report.
It's been moved and seconded that we report HB 102. Any further discussion? Clerk, open the roll. HB 102 is not reported by a vote of 4 to 6.
Thank you, Madam Chair, members of the committee. Thank you.
Then I see Delegate McQuinn. I believe you were here first. You have HB 1414.
Yes, Madam Chair and the committees. I bring before you this afternoon to present HB 414, and there are 2 amendments. One of the amendments I want to accept, and the other one I want to strike. So do I substitute?
Please, if you would report the substitute.
Yes, Madam Chair. So the substitute before you all, if you look at lines 29 through 32, some language has been added to kind of explain that how the hospital administrator or chief executive officer could then get charged for failure to report, showing that they have been informed by any person 18 years of age or older who was associated with or employed by any public or private organization responsible for the care, custody, or control of children with any reason to suspect that a child is an abused or neglected child. And then on lines 110 through 118, subsection E is where the new misdemeanor and felony offenses are. That is new language, and the delegate would like to strike on line 111, knowingly and intentionally.
Yes.
The amendments have been reported. Do I hear a motion?
Move the amendments.
All those in favor say aye.
Aye.
Opposed? And if you, though, could explain now the intent of the amendments.
Yes, Madam Chair. So for subdivision number 11, the intent was to add an including section, it looks like, to show that the hospital administrators or chief executive officers of these places that are public or private organizations responsible for the care, custody, or control of children, that those people would have a mandatory reporting responsibility if they were notified and aware that a child was abused or neglected. They would have the same duty that the individual that worked in, say, a hospital or a teacher would have to report if they knew that. The change for making the new subsection E is creating an enhanced penalty from what the current penalty is for failure to report based on where the offense occurred. It would be a class 1 misdemeanor for any person that's required to report to not report, and a second or subsequent violation would be a class 6 felony. It would exempt teachers. The amendment that I reported about removing the knowingly and intentionally language, under the current standard, it does say in subsection D, current law would say any person required to file a report pursuant to this section who fails to do so as soon as possible. There was some discussion back and forth, I think, with some stakeholders with the delegate, and they wanted to add some knowingly and intentional language. The delegate does not want that language, but it was after I had printed the bill. But the language that just simply says who fails to do so would be current law for every other mandatory reporter as well.
Thank you. Delegate McQuinn.
Thank you. Thank you, Madam Chair, and thank you, Mr. Attorney, as well. So House Bill 1414, actually, this bill came about because of some tragic situations that happened that became very public and went on, and individuals failed to do what they should have been, lawfully should have done. But anyway, this bill creates a Class 1 misdemeanor for any person required to file a report pursuant to relevant law who fails to do so as soon as possible, but no longer than 24 hours after having reason to suspect a reportable offense of a child abuse or neglect where such reportable offense is alleged to have occurred at a private or state-owned hospital, institution, facility of which children have been committed or where children have been placed for care and treatment. The HB 1414 is really, the intent is to strengthen the existing law that requires certain professionals to report suspected child abuse and neglect. It clarifies when and how mandated reporters must act and increase consequences for failing to report. And who are we asking to report? The current law already requires a wide range of professionals to report when they reasonably suspect child abuse or neglect. But this includes the doctors and nurses and other healthcare workers, teachers and school staff, trained adults, and it goes on, court-appointed advocates, among others in official roles involving children. And the reporting required mandated reporters must notify either the local Department of Social Service where children live or where the abuse is believed to have occurred, or the department toll-free child abuse and neglect line. Report can be made orally and must be followed by written report on a prescribed form. This just clarifies and expands penalties. Under the current law, failure to report within 24 hours can result in fines up to $500 for the first failure, not less than $1,000 for subsequent failures. If the unreported situation involves serious sexual offense, rape, aggravated sexual battery, failing to report is a Class 1 misdemeanor. HB 14 proposes to expand these consequences further, making such failure more clearly punishable as criminal offenses in specified institutional setting. And so there are, Madam Chair, there are individuals who are here to also speak to this. As a matter of fact, the Commonwealth Attorney of Henrico County and others. And so I would love to give them an opportunity to come and speak to this particular issue. Thank you, Madam Chair.
Thank you, Delegate McQuinn. Seeing no one on the committee wishing to ask any questions, I am going to go directly then to those who wish to speak in favor of HB 1414. Would you all please come forward so I can see how many? So if you all could split 5 minutes, I would appreciate it.
Yes, ma'am. Good morning, Madam Chair. Are we ready? Okay. Yeah, it's 6 o'clock. I wasn't sure. I am Shannon Taylor. I am the Commonwealth's attorney for Henrico County, and we did approach Delegate McQuinn to carry this bill. This is in direct response to a case that played out in Henrico County. I'm going to offer some facts that I can tell the committee have already been presented in open court, so this is all public knowledge. This came from the Henrico Doctors Hospital that is located in Henrico County, involving some babies who were in the NICU in the care of Henrico Doctors Hospital. And there was a CPS notification that came out on September 21st of 2023. But what we learned from the information through investigation is that there was a first baby with non-accidental injury fractures that was discovered on August 5th of 2023. There was a second baby that was discovered with non-accidental fractures on August 16th of 2023. There was a third and fourth baby separately found with non-accidental fractures on September 3rd of 2023. And what we know is that at least somewhere between August 5th to September 21st, and we do not know exactly when, Madam Chair, but we know that almost 7 weeks it took for the hospital to call Henrico CPS And during that time, outside counsel was retained and an internal investigation conducted by the hospital was conducted. Ultimately, CPS could not identify a specific individual, but they did make a founded complaint of level 1 for physical abuse without identifying a particular subject, but did say it had to be an employee of Henrico Doctors Hospital. Now, that is all relevant to our request for why we came to Delegate McQuinn. To understand, as I know, Madam Chair, you do and others here, is that CPS, Child Protective Services, they do everything they can to keep abuse from happening. And we certainly know that when we're talking about children under the age of 2, there's an automatic 24-hour response that is required. And that is so CPS can take the actions necessary to put in a safety plan to make sure that babies are safe. That was not done. If this had been done the right way, we would have known that on August 6th, August 7th, a safety plan would have been in place. Perhaps these other children would not have been harmed. And then, of course, we know that CPS reporting regulations exist for a reason, to use the investigatory function to protect vulnerable children. By delaying reporting and investigating, an entity can circumvent the regulatory safeguards that exist to keep children safe. So while I recognize that this was a very specific case that happened in Henrico County and that there are certain things that we cannot go into right now in terms of other actions on the hospital because of where we are in the posture of our case, we did feel like it was necessary that we wanted to take the time now to bring this to the attention of this legislative body to see if we could, in fact, tighten up our aspects of compliance, of reporting, and making sure that there's no confusion as to who is to be reporting when this information is known. Thank you, Madam Chair.
Thank you.
Good evening, Madam Chair. Derek Davis, Commonwealth Attorney for Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. We do support this bill. I can't tell you anything more compelling than you already heard about this story with these young children. But this does help to hold the people more accountable, and these are people that are trusted with the children. So it's a different level of people that are in custody, control, and care of those children. So it makes sense to hold them to a higher standard.
Thank you.
Lawrence Drumbett, I'm with the Virginia Education Association. We had some concerns with the initial version of this bill. It was over-inclusive, included schools. We'd reached out to the sponsor, and we have excluded school personnel from the reporting requirements. And the reason why is there are 1,000 investigations of out-of-family personnel for some minor incidents. It's grabbing a kid by the arms and swinging them. And all those school personnel are held out of school. So we wanted to make sure that they were excluded from the bill, from the recording requirements, so we don't have school personnel doing reports they don't need to do that take away time from DSS. Thank you.
Thank you. And I see no one else to speak. Is there anyone in the room who is speaking in opposition to HB 1414? And online, I also do not have anyone who signed up to speak. So, Council, is there anything that you would share? Any concerns that we need to be aware of? Seeing none, Delegate McQuinn, you have the final word.
Thank you, Madam Chair. Madam Chair, this bill aims to protect children more effectively by reducing barriers or uncertainty that might delay reporting abuse or neglect. It reinforces the idea that protecting children is a shared responsibility across the health, education, justice, and community sector. And it also, by ensuring clear penalties and accountability, it encourages timely reporting, which can lead to quicker intervention and support children who may be at risk. And so I hope it to be the pleasure and of the committee to favor us by supporting this bill.
Thank you.
Second.
It's been moved and seconded that we report HB 14 as amended. Substitute as amended. Any further discussion? Clerk, please open the roll. Members, cast your vote. HB 1414 reports with substitute as amended by a vote of 7-3.
Thank you, Madam Chair, and thank you, committee. Appreciate it.
Okay, as I have seen people come in, our next presenter, next patron will be Delegate Reeser, followed by Delegate Maldonado, followed by Delegate Hodges. Delegate Reeser.
Thank you, Madam Chair. Madam Chair, I'm here tonight to present to you HB 124. This bill is a bipartisan recommendation of the Committee on District Courts. It simply amends the definition of assault and battery to include retired district court judges who are recalled to serve. Currently, the law includes retired circuit court judges under temporary recall in the definition of judge for assault and battery protections. Retired district court judges, however, are not currently included, even though they perform similar judicial duties. So as a result, assaults against recalled district court judges are not treated the same as their circuit court counterparts, and this bill would fix that problem.
Thank you. And this is the recommendation of the Committee on District Courts?
The Committee on District Courts, yes.
Are there any amendments? Any questions from the
I have a
committee?
question.
Delegate Williams.
Just a question for the patron. Have you had some issues with the retired judges getting assaulted?
There was no testimony given in the commission meeting regarding the facts that gave rise to the need, but I would say, Madam Chair, to the delegate that being prepared to handle a situation that might arise is a good enough reason to make sure the code is consistent.
Yeah, Madam Chair, just a follow-up. Yeah, I agree. I was just curious if we had that issue happening.
Madam Chair, there is a member of that. There's a staff member from OES here who might be able to answer that question.
Would you? Thank you. Happy to have you share the perspective of the Office of the Executive Secretary.
Yes, Madam Chair, members of the committee, Eileen Longenecker with OES at the Supreme Court. We're not aware of any incidents. We think this was just an oversight, so retired circuit court judges subject to recall that are included in the definition, just retired district court judges subject to recall are not included. We just think it was an oversight.
Thank you. Seeing no one wishing to speak, is there anyone in the room who is here to speak in favor of HB 124? Any opposed? No one's online. You have the final word.
Nothing to add, Madam Chair. Thank you.
Second.
It's been moved and reseconded that we report HB 124. No other further comment. Open the roll. Members, cast your vote. HB 124 is reported by a vote of 9 to, whoops, we got one more. Yay. Is reported unanimously on a vote of 10 to 0.
Thank you, Madam Chair and committee members.
Delegate Reeser. And our next presenter is for HB 662, patron Delegate Maldonado.
Thank you, Madam Chair. Good evening, Madam Chair and committee members. There is a substitute.
Move the substitute. Second.
Moved and second. Anyone, all those in favor say aye. Opposed? Substitute, would you like to speak to it?
Thank you. Thank you, Madam Chair. The substitute has a number of fine-tuned definitions, and the part that's not definition in nature includes provisions in two separate places that says that any person who, with the intent to defraud, acquires or retains possession of a gift card or gift card redemption information without the consent of the gift card holder, gift card issuer, or gift card seller is guilty of theft. I want to explain the bill more broadly. This is addressing gift card fraud. Many people may know that there is a crisis happening, a problem with people taking gift cards, buying them in bulk, adjusting the information on the back so that when people actually go to buy them, that money, they're having access to those cards when they activate them and use those codes. So the U.S. gift card market reached $447.7 billion in 2025, highlighting the industry's value and importance to consumers. Along with the market growth, fraudulent schemes tied to gift cards have grown exponentially, undermining public trust causing significant financial loss and enabling broader illicit schemes. In fact, organized transnational fraudulent networks are using sophisticated methods to compromise gift cards, launder money, and commit large-scale theft through various illicit schemes, including tampering and consumer-targeted scams. And so we need state laws that specifically address gift card tampering and scams to protect consumers from this growing form of retail fraud. Some people right here in this room may have somebody in their lives or know of somebody in their orbit, in their circles, that is the victim of gift card fraud. Sometimes this also happens, and it specifically targets some of our younger folks, maybe younger folks in entry-level positions, as well as some of our seniors. So the solution, what we're trying to do, is to better protect consumers from financial harm and maintain confidence in the gift card market. So we're adopting things like this, we hope, legislation, which is a companion to the SB 444 in the Senate, that focuses on safeguarding the public and ensuring victims have a pathway to justice. So it protects the consumers from tampered cards by establishing specific laws that address gift card tampering, and by holding offenders accountable for the potential loss. It also safeguards against unauthorized use of gift cards, implementing clear penalties for unauthorized use and receipt of stolen gift card redemption details, by closing legal gaps to make it easier to pursue those who exploit consumer data and ensure faster recovery for victims. And finally, it shields consumers from scams, providing more tools that help protect them from fraudulent scams and around gift card information. I will pause there. That is the bulk of the bill, and we hope that it will be the pleasure of the committee to report this.
Are there any questions of the patron? If not, let me hear of those who may be here to speak in favor of 662. I see if you all can keep this to 5 minutes. Thank you.
Madam Chair, members of the committee, Jody Roth on behalf of Virginia Retail Federation. I want to thank Delegate Maldonado for carrying this bill and for explaining it so well. So my comments will be brief. While retailers are investing heavily in tamper-evident packaging and employee training, they cannot innovate our way out of a loophole in the criminal code section. Currently, our law does not give them the tools to do so. This bill will provide that for them. The legislation is about more than just retail loss, as Delegate Maldonado already explained. It's about consumer protection, especially our most vulnerable, the elderly, when they go to buy these cards and load their money to provide gifts for their grandkids or friends or family members. So we want to do all we can to protect them, and we appreciate the delegate bringing this bill. Thank you.
Evening, Madam Chair. Jared Calfrey with AARP Virginia. We support the bill. Gift card fraud is one of the most common ways that seniors are targeted for frauds and scams. Just one quick example, we have a woman who advocates for AARP now who was the victim of a romance scam where someone talked to her on Facebook, convinced her that they were in a relationship. She sent him gift cards. She sent his daughter at boarding school gift cards, she thought. And by the time it was over, she'd lost $40,000 and wiped out her life savings for this person who was scamming her. So we appreciate the delegate for bringing the bill forward and hope you'll support it.
Madam Chair, members of Subcommittee, Matt Benedetti representing the Home Depot. We support the bill. We thank the page for bringing the bill. This is a serious problem, and we need some help on this. So any consideration you can give, we appreciate it.
Madam Chair, Derek Davis, Commonwealth Attorney for Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. This is a much-needed bill. So to give you one quick example, there was just recently a $14 million scheme by a couple defendants down in Texas. What they would do was take the gift cards off the rack, take them home, get all the information out of them, take them back, return them to the rack, and then when someone purchased it and added money to the card, they would then spend the money off the card before that person ever got home. We've also heard a number of stories around the Commonwealth of these gift card scams. And some of the reasons we need this specific code section are the definition for credit cards in 18-191, which would apply to all of your credit card thefts and forgery, does not include these gift cards. Specifically, it says that the credit cards have to be something on credit, and then when it expands to debit cards, it says it must be drawn on a bank. So those don't apply here. Additionally, In the scenario I just gave you, grand larceny's not going to apply because when they took the physical cards, there was no intent to permanently deprive. They intended to put them back. Additionally, the obtaining money by false pretenses won't work because at the time they are taking the money, there's no misrepresentation of a present fact. So this is a needed bill to fix a hole in the code. Thank you.
Thank you. Seeing no one else, is there anyone here to speak against 662? And we have no one online. Delegate Williams, do you have a question?
Yeah, for the patron. Does this include prepaid visas or debit cards at all? Or is it just like your regular traditional gift card that we would think about?
Madam Chair, I would say to the delegate that this is all sort of closed loop and open loop gift cards, so it's gift cards only. There are separate banking and other regulations that apply to debit cards and credit cards.
Seeing no further questions, Council, is there anything that we need to be aware of? Okay, thank you. You have the final word.
I think our folks who provided testimony did a great job explaining it. I'd just like to thank them and the Virginia Retail Association for helping put this together and bring this to our attention so that we can address it for our consumers.
Thank you, Delegate Maldonado. We operate by motion.
Move the report.
Been moved and seconded that we report HB 662 with substitute. All those in, please open the roll. Members, cast your vote. HB 662 passes unanimously by a vote of 8-0. Thank you very much, Delegate.
Thank you, Madam Chair, members of the committee.
Okay, Delegate Hodges.
Thank you, Madam Chair. Good evening, everyone. You have before you House Bill 1103.
1133 is before us.
Yep.
Is there a substitute? Nope.
No, ma'am.
You're on.
Okay, great. Thank you. And if you recall, Madam Chair, carried legislation passed adding xylazine. Anyone that manufactures, sells, gives, distributes, or possesses with the intent to manufacture, sell, give, or distribute the substance, xylazine is guilty of a Class 5 felony. And xylazine actually it's an animal sedative. And what we're doing is adding metadonidine, which is 100 times more potent than xylazine. Causes respiratory depression, sedation, death, and unlike, it is a non-opioid. And since it is a non-opioid, it cannot be reversed by Narcan, and it's starting to show up in some of the opioids. So we're trying to go down this path, adding this drug.
All right. Are there any questions of the patron? Seeing no questions, is there anyone in the audience wishing to speak in favor of HB 1103? Wishing to speak against? Seeing no one online. Council, is there any concerns that you would like to raise? None? Okay. You have the final word then.
Hope it's a pleasure of the committee to pass the bill.
It's been moved and seconded that we report HB 1103. Hearing no, is there any further discussion? Member, Clerk, please open the roll. Members, cast your vote. Okay, HB 1103 passes unanimously by a vote of 8-0.
Thank you, Madam Chair.
That concludes all of the patrons that I see. We have only one that is not on the committee, so we're ready to go to the committee. I will say that some generous soul, I'm not sure who did it, but thank you, did provide pizza in the back room. So if you'd like to have a little pizza, we probably have another hour, hour and a half, who knows, yet to go. as we get through our own bills. Does anyone want to, I mean, you certainly are welcome to take brief breaks if you want, or do you want to take a 5-10 minute break before we start into our own bills? I think I'm hearing a 5-10 minute break. Okay, stretch and come back at, please let's convene at a 6:45. Subcommittee will come back to order. And the next bill we'll take up is HB 629, and then that will be followed by the two bills from Delegate Hope.
Thank you, Chair Watts. I'm pretty sure I have a substitute to introduce.
Second.
Awesome.
All those in favor say aye.
Aye.
Opposed? We have adopted the substitute robustly.
Perfect. The substitute is responsive to getting together a variety of stakeholders to just make sure that we were tackling this the best way possible. So, I pulled in advocates from the advocate community, pulled in my Commonwealth's attorney, pulled in our DLS staff, and arrived at this as being a path that we were comfortable with. I will tell you the purpose of the bill. It came to me from my, I think he's called Deputy Commonwealth's attorney now, where for sexual extortion in particular, there was some confusion around whether you could do attempted sexual extortion if the sex act that you were trying to induce never occurred. So if you took the images, you threatened someone with images, or we can go by the code, so you maliciously threaten in writing with the intent to sell and give out images or whatever the sexual images are, with the intent to cause that person to have sex with you, you would be guilty of this. But the problem is, because there's two elements to it, prosecutors didn't always feel like they could say, well, you threatened them in writing, you had the images, but because they didn't have sex with you, I guess you're not guilty of anything. Normally there's a different code section, and I'm sure DLS will correct me if I'm wrong, but there's a different code section that just kind of uniformly captures all attempts. But because of the way this was written, it turns out my Commonwealth's attorney was not the only one that was encountering difficulties and confusion around it. So they were asking for clarification that obviously, I would like to think, obviously, if you are trying to extort someone for sex acts, even if they don't have sex with you, you are clearly doing some kind of attempt of that crime. So the other part is like sort of a cleanup, since we were touching the same areas of the code, and it's really clarifying. This was work that I think might have been done in one of our prior sessions, that even if you do not fully expose the genitals and all of the things that are in that list that I'm not going to list out because it's too late, if it's defined as obscene, it would still be in the category of penalties that are included in 18.2, 386.1. I'm going to stop there and take questions if you have any.
Are there any questions of the patron, of counsel? So I'm going to, do we have people to testify? Then let us hear then from those who are here to speak in favor of HB 629.
Derek Davis, Commonwealth Attorney for Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. We do support this bill, Madam Chair. It fixes an issue that we've been dealing with for a long time. And first, it creates the attempt crime for what we commonly refer to as sextortion. And that's where they're threatening to reveal these nude photos, post them on the internet if they don't perform sex acts for them. And because of the way the code is written, it did require that the sex act had to occur. So this does make that clear that there is that attempt now. Additionally, the second part in 18.2.386.1 on the unlawful creation of images includes a case that is pretty common where it's not a victim in the nude or in the undressed. They may have clothes on and may be performing some sexual act that would not have been covered previously. So it covers those issues that we've not been able to prosecute in the past.
Thank you. Are there any questions of the witness? Yes, Delegate Delaney.
Thank you. I'm trying to think how to phrase what I wanted to ask. So is there, and this might be a question for counsel too, is sextortion for money already on the books in Virginia, and is that something prosecutable, or are we, I guess where I'm getting at is you're narrowing it to a very specific type of extortion, which is important, and I support everything you're doing. But I'm also just kind of asking, understanding how a lot of sextortion is for monetary gain. If that's a separate bill, which is okay, if it's already the law, but I'm just kind of wanting to see where that falls in with this.
If it's all right, I'm actually going to yield to either DLS or the Commonwealth's attorney because...
Perfect. I can answer that, Madam Chair and Delegate Delaney. Unfortunately, I've been here long enough to remember when bills are passed. So this was actually something that our old chair, Rob Bell, was kind of championing back in 2023. This went, sextortion went through the House, went through the Senate, had some changes. So finally, that was the version that we ended up with, which is the subsection A. And then last year was when subsection B was added, and I think that was Delegate Walker. Subsection A is about the actual sextortion. Subsection B deals with threatening eviction or loss of housing, kind of dealing with like a slumlord situation.
Council is bringing back memories.
I'm just, I'm clarifying as I look at the language on line 34, hopefully I'm on the right version of the substitute, that anyone who maliciously threatens a complaining witness. So it means that you're not soliciting, but you're threatening. I mean, this is a distinct from any crime that we have of solicitation.
Yes, Madam Chair. Under the current crime sections and subsections A and B, the person to complete the actual act has to maliciously threaten the eviction or maliciously threaten in writing, which could include electronically transmitted communication, the threats to disseminate or not take down the images or just threaten to evict you or get rid of your housing situation, et cetera. So by adding any person who maliciously threatens in violation of subsection A or B, it's still tying it back to what current law is.
Thank you. Seeing no other questions online, I'm double checking 629. We do not have anyone who wishes to speak. Is there anyone who was speaking against 629? Seeing no one. Council, you've had the...
Did you want to fix?
I just wanted to note one thing, just in case anybody was confused about the language being added to 18.23, 86.1. Back in 2024, this same language was added to our dissemination statute, not the unlawful creation statute. That was Delegate Shin's bill, and I think it was me, but I think I inadvertently just left out the creation statute at the time. So this is kind of clarifying that they're not similar. So now we're making them the same.
So now we've got a complete consistency then. Thank you. You have the final word, Delegate Coulson.
You know, we have a long day. So I will just say my own image was here to testify, or was going to testify in support. They are no longer here today. They did send a statement, which I don't need to read, but they are in support of the bill.
Thank you.
Move to report.
Second. It's been moved and seconded that we report HB 629. Any further discussion?
Move to report with
Clerk,
substitute.
open the roll. Members, cast your vote. HB 629 with substitute reports unanimously 10-0. Delegate Hope.
All right, Madam Chair, I have House Bill 489, and I do have a substitute.
Second. All those in favor say aye. Opposed? Please proceed.
Thank you, Madam Chair. House Bill 489 with a substitute seeks to standardize restorative justice practices. You can see we have definitions that we establish: restorative justice communication, restorative justice facilitator, and restorative justice practice. The second focus that the bill does is it wants to standardize protection across Commonwealth, moving away from fragmented local agreements to reliable state statute. It does that by defining what those practices are and lays out clear communications that are privileged and when they are not subject to privilege. We already have protect communications with mediators, clergy, and therapists, and it's a logical step to have the same privilege when you have these restorative justice practitioners. The bill leaves all the mandated reporting requirements intact. If a threat to the community or safety or a child is disclosed, those legal obligations still apply. And of course, it balances the need for private healing and with the necessity for public safety. And so that's really the bill before you. We want people, when you go into this situation, to be able to disclose information, but at the same time, we draw limits of what's excluded from those communications and not come up later on.
Thank you. Are there any questions of the patron? Seeing, yes, I'm sorry, Delegate Davis.
Thank you, Madam Chair. Question for the patron. Can you give me an example of what you're talking about what you're trying to prevent?
Well, I do have an expert online, and so maybe we can turn to her and maybe she can respond to that. They do this in Arlington, and of course they do it all over the Commonwealth, and so she can give some examples of why this is necessary.
If they're online, we have 4 speakers online. So let's go ahead and take testimony, and then we'll have further discussion. In the room, is there anyone here who would like to speak in favor of HB 489? I see 4, so if you all could keep it into 3 minutes, that would be great.
Madam Chair, Rob Hogan-Class from Justice Forward Virginia. We've been a member of this Restorative Justice Policy Coalition for the last year and a half working on this legislation. This is something that the restorative justice practitioners asked for. This is an alternative dispute resolution. It's different than mediation or arbitration. It's an attempt to really bring all the parties together and come to a resolution that everybody can agree on. And we support this type of diversion. Thank you.
Thank you.
Kate Hanger, I'm the Executive Director of the Virginia Victim Assistance Network, and we support this bill.
Good evening, Chair Watson Committee. Sheba Williams with No Left Turns, also a member of the Restorative Justice Coalition and a circle keeper for Richmond Restorative Justice. We support the bill. Thank you.
Thank you.
Taj Manheft with the Immunization Project, Chair Watts, members of the committee. Thank you. For everybody who's not a lawyer, courtrooms are scary places even when you're a survivor of harm, and restorative justice practices really need people to feel safe going to them. So we support this to encourage that to happen more often. Thank you.
Thank you. Seeing no one else in the room, is there anyone here that would like to speak in opposition to 489?
Madam Chair, Derek Davis, Commonwealth Attorney for Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. I want to be clear that the concept of protecting these statements in a restorative justice program, we have no issue with. The issue is with the language of the specific bill, and I have not seen the substitute that was just submitted, but the language in the original bill, and I don't know how much it's changed, is just extremely broad. And the definitions would cover, I think, many more circumstances than what might be intended. For example, the practice of any voluntary participatory process in which the parties have caused harm, parties who have been harmed, or other participants gather to do these number of things. Our interpretation of that is that's going to include any behavioral health docket. So you have a veterans docket where someone comes in and says, oh, also, by the way, I killed my wife last week. There's an argument there that that's not going to be admissible because of the definition of the restorative justice practices. So if it could be narrowly tailored so that we know we're talking about these specific restorative justice programs and that are legitimate programs, then I don't think there would be any concern. Also, some concern about Brady disclosure. So we have a constitutional duty to turn over Brady information. And I don't know if just the language of disclosures necessary to comply with another law would be sufficient to exempt that. So for those, I just want to
Delegate Hope, would you address at least the first comment?
I wanted him to go through that. I'm sorry to do that. The substitute included changes that we worked with VACA on. That's before you, so it probably addresses all your concern. Nate and I, we had extensive conversations about this, so we should give you the substitute.
Counsel, can you cite the word change that might help? Is it brief enough?
When did you talk about it? A couple weeks ago.
Here. Okay, let us go on then with the testimony while I'll give you a chance to look at the substitute. And now I'm going to turn to those who have signed up online, if they're still with us. First one is Allison Chafin from Survivors for Justice Reform. Allison?
Good afternoon. Good afternoon, Chair. Sorry about that, members of the committee. I'm Allison Chafin. I'm the co-representative for Survivors for Justice Reform, also part of the Virginia Restorative Coalition. And we want to first thank Delegate Hope for patroning this bill. We just want the committee to know that survivors are not a monolith, and many find the criminal legal system re-traumatizing. Restorative justice offers a voluntary path to healing, but for this work, honesty requires safety. So with this bill is critical because it ensures that a survivor's truth remains within restorative practices and cannot be used as a weapon in future litigation. So we urge you to support this bill to ensure restorative justice remains a confidential healing option for all Virginians, but especially for survivors. Thank you.
Thank you. The next one is Liana Rosell.
Yes, hi, thank you. I'm also with the Virginia Restorative Justice Policy Coalition, and I wanted to let you all know that restorative justice takes a variety of forms in Virginia. It's been used since the 1980s, including programs that take referrals from Commonwealth's attorneys and legal system partners, and programs that work with the community at large. And these practices all share a core principle, which people have been stating, that all participants must be able to engage voluntarily and honestly without fear that what they may say may at some point be used against them in a legal proceeding. Some of our programs and organizations operate under agreements that protect the confidentiality of restorative justice practices. However, not all have this protection, and none of us who are practitioners can guarantee this essential protection to community members who engage in RJ without going through legal system channels. HB 489 does that, providing that privilege, and we urge you to pass the bill. I'll also note the specific language that we worked on with VACA now limits the definition of restorative practices by saying the people are gathering with one or more restorative justice facilitators. So that plus the provisions that say that any things that would be otherwise discoverable are still discoverable, I hope will address the gentleman's concern. Thank you.
Thank you. The next speaker is Dr. Stephen Keener.
Thank you, Madam Chair. My name is Stephen Keener. I'm a professor of criminology at Christopher Newport University. I'm also the director of our Center for Crime, Equity, and Justice. I support restorative justice wholeheartedly. Any way we can increase pathways to restorative justice is a good thing, and I think is well supported in the research. I second all of the other things that these wonderful practitioners and experts have said. I also want to add that I take a group of students to Norway and Denmark every year, and we study their restorative justice practices as well as their justice system in general. And they do restorative justice a lot. They do it really well, and it's very effective. And one of the keys is confidentiality throughout the process. And that allows for them to practice effectively and extensively throughout their system. So I strongly support this bill, and I thank the patron for carrying it.
Thank you. And I also have Parissa Delahani Tufti. I don't see that she is on the line. That then is a list of speakers. I will return to Vaka's comments about the substitute.
Yes, Madam Chair. It does appear the inclusion of the restorative justice facilitator does limit it some, so that limits certainly who would be running this program. But I think it's still too broad without some more parameters about whether or not these people have actually entered into this program, who's doing it, what qualifications they're going to have. So I think there would still be some concerns around this language, but I think it's going in the right direction of making sure that we are getting people in a legitimate program if we're going to protect it. I don't see anywhere in here where there would be the exception for Brady disclosures, and I'm skimming through it quickly, so I may have missed it.
All right, thank you. And certainly halfway through the session, it's nice to make good progress. Are there anybody else who would like to speak? Council, do you have any concerns you'd like to share?
Not necessarily a concern, Madam Chair, but I would say to Vaka's point that there are certain sections that do say numbers, subsection D, 1, 2, 3, and 4, that do list reasons that you could disclose. And I think their point is well taken that it doesn't explicitly say to comply with Brady about the impeachment evidence. However, it is a court case that is still standing in good law that people comply with. So there's an argument for both ways. It doesn't explicitly state that it is based on the court case or case law. However, it would be standing precedent law.
Thank you. Okay. Looks like you have the final word, Mr. Overchair.
Move to report.
You asked.
It's been moved and seconded that we report HB 849, HB 489 with substitute, not amended substitute, with substitute. No further comment. Clerk, please open the roll. Members, cast your vote. HB 489 reports with substitute by a vote of 7-3. Thank you.
Thank you, Madam Chair. I next have House Bill 548.
Yes,
I don't
HB
think I have a substitute.
548 is before us.
For this 548, do I have a substitute for it? I do. Oh, I do. I have a substitute. I knew that.
Second.
Okay, all those in favor of the reporting the substitute, please say aye. Aye. Opposed? Please prefer.
Thank you, Madam Chair. You're aware of these types of bills. Uniform Law Commission brought this Uniform Healthcare Decisions Act to me. This has been a multi-year collaboration effort. I believe I carried this bill last year and got a stakeholder group together, and they've met for many hours walking through this. This seeks to improve and modernize Virginia law around advanced care planning directives and decision-making. Specifically, the bill better enables individuals to appoint agents to make healthcare decisions for them. It eases the process of providing healthcare professionals and surrogates with healthcare instructions. It authorizes decision makers for those who have not been appointed an agent without the need for appointing a guardian or going to court. It also updates and modernizes the default surrogacy process to include non-traditional familial relationships and living arrangements, and it specifically addresses advanced directives in the area around mental health care. Again, the bill was initialized last year. We've had numerous stakeholders. I do have an expert in the room from the Uniform Law Commission. You do know exactly how these things work because it is uniform. They want to try to keep this as standard as possible. Several states are starting to move in this direction. And so, you know, we want to, but this whole time that the bill that's before you does stay true to what the ULC seeks and to have that uniformity. And so obviously this will always be a continued conversation, and I'm working with the stakeholders. If they have other things that we can stay within those parameters, we're certainly willing to consider along this way. But I'll yield for any technical questions. I do have an expert from the ULC
here. I would
here.
appreciate first that we bring forward the representative of the Uniform Law Commission for any additional perspective.
Madam Chair, Chris Nolan, I'm here today in my personal capacity as the chair of the Virginia delegation to the Uniform Law Commission, and I don't think we've ever had a bill before House Courts Crim Law Sub. So if I could, just for 45 seconds real quick, for those of you who may not be familiar with it, if you ever suffered through secured transactions in law school, the Uniform Commercial Code is a product of the ULC. And basically, it is a conference of about 400 attorneys, practitioners, judges, legislators, and law professors. And this particular act was considered over about 2 years. And the way the commission works, you have a small group about this size who works with stakeholders on a uniform act. In this case, they were updating an act from 1993. And it goes through a very rigorous process. It has to go through a 2-year process where 400 of us get together in a conference room every summer, and every act is read line by line, word by word, and anybody can get up to offer amendments or otherwise debate the merits of the bill being proposed. On the line should be Sarah Cannon with the ULC's main office in Chicago, who was the staff attorney, legislative counsel for this particular act. And I hope she's still there because she is the one that can answer any substantive questions on this. I'm here to do the rah-rah cheerleader part. And I just want to say that the AARP, who's behind me, led the stakeholder discussions here in Virginia. And we also have a Virginia practitioner as well that is here to answer questions. So, Madam Chair, thank you for your indulgence.
Good evening. I'll be really brief. I'm Nathan Kotkamp. I'm actually the chair of National Healthcare Decisions Day, which was actually born out of an initiative here in Virginia. I am the proud primary author of our current law. I was also a member of the ABA's commission as a delegate to the uniform law, and I think it's even better than what we have today. So that's saying a lot. I hope that means something to you. And I really do hope that Virginia will be one of the leaders in adopting the uniform law, because it will help what I do on a national basis. So thank you.
Let me ask a basic question, since you have done both.
Yeah.
What is the major change that is going to happen as we move to the uniform law?
The uniform law does a variety of things to sort of clean up some of the things that are currently in Virginia law. So, for example, if you do not have a designated agent and you have to go through sort of the pecking order, if you will, so you start with your spouse and then you go to your children. Right now in Virginia, if you get to the end of the list of family members, there is a possibility of the designation of someone who's not a family member. But they're very limited. It's a very restricted role. And so one of the things that this law would do is to expand the decision makers by default to include folks like unmarried couples that have been life partners, or someone who is, that loving neighbor who is almost as close to being a child of the older neighbor, and they are engaged in healthcare and things like that. So that's one of the ones. Also, some facilitating of oral designations of who would be a good decision maker, whereas right now we have a great process. It's very secure, but it's probably too secure for what we really need in practice in healthcare. So happy to answer any other questions, but those are two of the real highlights of what this law would do. And again, we've got a great law in Virginia, but this is better, and I hope that you guys will recommend approval.
I'm going to suspend hearing from ARP because I'm going to assume that's testimony in favor of. Are there any other questions of the patron or of the people with the Uniform Law Commission? If not, and see no one else wishing to speak, now you may come forward. Those who want to speak for HB 548, please come forward.
Thank you, Madam Chair. Jared Calfee, the ARP Virginia, and I'll be very brief. And to answer your question, I think broadly, what this does is ensures that advanced care, end of life, situations of incapacity, that a person's decisions are honored. It makes it easier for that to happen. It makes it easier for you to designate someone. It makes it easier to ensure that how you want the situation handled is how it's handled, without it having to go to court, without having to appoint a guardian, all those things. And so that's why we support the bill. And I also just want to thank Delegate Hope for bringing together a great group of stakeholders and putting a lot of time and work into getting everyone's opinions on this. And we did make some tweaks to, we think, improve the uniform law while keeping it uniform, but making sure that there's some safeguards in place that were really important to various stakeholder groups here in Virginia.
Thank you. Is there anyone wishing to speak against HB 548?
Madam Chair, members of the subcommittee, Jeff Caruso with the Virginia Catholic Conference. So this is a very large undertaking, and the vast majority of the provisions in here we have absolutely no problem with. And I haven't seen the substitute, but as far as the original bill, there were a few reservations that we had. I think mainly if you look at 54.1-2993.22, the duties of the healthcare professional and the healthcare institution, this seems to be, and subsection F and G in particular, it seems to be a rewrite of at least part of the section on what does a physician do in the case of medically or ethically inappropriate care. And we were a part of a work group probably 8 to 10 years ago that carefully crafted a solution to that. And that's current section of the law, 54.1-2990. And this bill would repeal that. And we would feel very strongly that we would want to see 54.1-2990 remain in the law. And then in addition, there are a couple of sections where we feel that there could be a stronger presumption in favor of providing nutrition and hydration. The form on 54.1-2993.12, and then also in the limitation on powers in 54.1-2993.20 has to do with individuals with long-term disabilities. And we think that because when the disability is increased, that should not be a reason necessarily for not providing the nutrition and hydration. So these are just some of the concerns as this bill, if it continues to go forward, we would really welcome the opportunity to work with other stakeholders. Thank you.
Thank you. And now online we have two individuals, one speaking for, one speaking against. The individual, Sarah Cannon, is also from the Uniform Law Commission. Sarah?
Thank you, Madam Chair. I am a staff attorney with the Uniform Law Commission, and I am here to make myself available in the event that the committee has any questions.
Thank you. And also then we have Olivia Gons-Turner from the Virginia Society of Human Life. Olivia?
Good evening, Madam Chair. Thank you. Good evening, Madam Chair and members of the committee. VSHL was a part of that commission several years ago that also helped to draft some of the current standing code law. Our organization supports many of the sections that were highlighted to you. We are not in complete disagreement with the concept behind this initiative. We want the patron to know that there are some suggested amendments that we have discussed with legal advisors who are a larger part of the national disability rights programs in the country. And these are concerns that we think could be addressed within this bill if we were to perhaps gently lay on the table, if VSHL might be so bold as to recommend that, so that those of us who were original stakeholders, including some of the disability rights groups here in Virginia who have some concerns about the bill as well, could present those amendments and changes that would answer some of the concerns raised by Mr. Caruso, which we share, but also would perhaps even expand our ability to clarify and provide greater assistance, particularly to individuals living with disability or who may, as has been pointed out, become more disabled in the process of care. And a great concern to us is that while we definitely want to be able to have proper advanced conversations so that people have support systems around them, one thing to consider might be expanding the way guardianships, etc., are arranged in Virginia so that it is not so cumbersome, so that an individual without support or care could actually have the appropriate speakers on their behalf that totally got their interests and, forgive me, no one else's interests at heart. So we really appreciate the effort made by the patron. We would like to see this bill perhaps continued to next year so that those of us who were part of the original commission conversation could bring forward to him some of these concerns and we could really make this bill something important for the circumstances in Virginia. Thank you, and good evening to all of you.
Thank you. Seeing no one else wishing to speak, Delegate Mehta.
Thank you, Madam Chair. I just had a question in response to Ms. Turner's testimony. She mentioned that there are disability rights organizations that may have some additional problems with this, and I was hoping that that could be fleshed out in terms of which organizations she was referring to.
Yes, are you still online? Please proceed.
Yes, Madam Chair, I am still online. One of the organizations that Virginia Society of Human Life has had conversation with are the independent living groups in Virginia. And we know that they have reservations about the bill as it currently stands because it could, in fact, impact the ability of severely disabled people or people without an ability to communicate their wishes to have the appropriate care, including something as simple as nutrition and hydration, which in many cases is life-saving, is not extraordinary, and is one of the things that we fought very hard for in the original commission several years pre-COVID. That commission took place when Delegate Stolley was introducing legislation that was something related to this, but the primary concern they and we have is that we do everything in our power to ensure that individuals living with disability are not at a disadvantage and that to be frank, one of the concerns we share with them is that hospitals or other agencies that may have a cost question put in play because of treating or continuing to care for disabled people, severely disabled people in particular.
Thank you very much for thank you very much for that perspective. Delegate Hope, do you have any response?
Yeah,
or
I mean,
any?
my only response is the Disability Law Center has been part of this stakeholder group, and they've made a number of different improvements to the bill. I know that they're neutral on the bill, but we continue to work on the bill. I don't think this puts the perspective of nutrition in a worse posture than our current law. And I would ask those to put them side by side. But we are working with disability groups. They're all part of the stakeholder groups. And again, you know how the uniform law works. We need to stay within those parameters to make sure that this is uniform. This is going to be something that's going to take over the country. And so we need to make sure Virginia responds. And so we're staying within those. And again, this whole process, I'm open to comments from Mr. Caruso and others. This is a consensus document. And so to the extent that we can make those improvements and the consensus remains and we stay within those parameters from the Uniform Law Commission, we're certainly open to doing that.
Thank you. If there are any comments from council? If not, then unless you have an even better closing statement.
Move to report to substitute.
So moved.
I thought we did. My apologies. Okay, so it's been moved and seconded, a little late, but it's been moved and seconded that we adopt the substitute. All those in favor say aye.
Aye.
Opposed?
We already moved to report.
Yeah.
Now we're moving to
report with substitute.
Okay. Is there any further discussion? Clerk, please open the roll. Members, cast your vote on reporting with substitute. HB 548 is reported 7-3 with substitute.
Thank you, Madam Chair.
I am going to go ahead and pull just a teeny bit of rank because what we have left is two bills that I have, also Delegate Williams and Delegate Schmidt. So if you would, Chair, please, Delegate Williams.
Of course. Is there anyone online for either of hers? No. Okay, perfect. Madam Chair, when you're ready.
Thank you very much. I would like to start, please, with HB 251.
Floor is yours.
Okay, thank you. HB 251 came to me from an individual that actually I only met her yesterday, a sweet, wonderful woman who endured the loss of a man that she'd had a long-standing relationship, and there was an assault and battery, and approximately, I'm sorry, I don't have the exact details with me. I don't think she's going to be able to be online, but he died of the head injuries that he suffered in the assault and battery. They went through legal proceedings, and all that was found was assault and battery. There was no enhanced penalty for the loss of life. So therefore, what I have before you is a bill that creates, and forgive me while I bring it before you, it creates the sentencing guidelines, but the actual language that we are dealing with is on my copy, lines 94 through 96. Any person who commits an assault and battery resulting in serious bodily injury as defined in 18.2, 51.4, and that includes permanent disability, disfigurement, again, serious bodily injury, but does not rise to the level of unlawful or malicious wounding in violation of 18.251 is guilty of a Class 6 felony. It establishes that midpoint. We have a number of, as we've been hearing, voluntary, involuntary, malicious, et cetera, but it establishes a midpoint that I can best liken to what we do with DUI or drunk boating or improper handling of a firearm, that if you have this kind of loss of life, serious bodily injury, that there is an enhanced penalty for it.
Thank you, Madam Chair. Questions from the committee? I see Delegate Williams.
Yeah, a question for counsel. Since she brings up malicious wounding, I was wondering if you could walk me through the differences in what this bill is creating and then what malicious wounding is.
So in Virginia, the felony assaults we have aggravated malicious wounding, unlawful wounding. They all have the same elements of a specific intent to kill, do serious bodily harm, maim, disfigure, disable. So the specific intent element is necessary for all three types of wounding. And then aggravated means there was some sort of permanent injury, and the courts have interpreted that to be, could be a scar, could be, whatever. Malicious means there's not a permanent injury, but there was some sort of injury and it was done with that specific intent. Unlawful, you still have the specific intent to do bodily harm, but it's the same as voluntary manslaughter. It's in the heat of passion, adequate provocation, so there's no malice. And I'm sorry, malicious wounding and aggravated malicious require malice. This would just be an assault that would not have the specific intent to do the serious bodily harm, but by whatever acts serious bodily harm was done. And yeah, if that answers your question.
It does. Could I have a quick follow-up?
Follow-up,
This really feels like the criminalization of the eggshell rule, the eggshell plaintiff rule.
Arguably, yes.
And you said that malicious wounding does not require a permanent disability. This would kind of fit that role.
Right, aggravated requires a permanent injury. Malicious just requires a bodily injury, doesn't have to be permanent.
All right, thank you. Any other questions from the committee?
If I hope I'm responding appropriately. My son is 6'5" and played football at 250. And he grew big from the beginning. And I always told him in the playground that if there's any fight that breaks out, you stay away from it. Because size alone, I wanted him to be responsible for that size and know how intimidating and how sometimes his push is different. So that when I look at this, I look upon the circumstances that while you might not be able to prove intent, if Troy hits me, if my son hits me with that same force, it's going to be a different result. And I do think that whether we're talking about the behavior of DUI, where you're consciously doing something which makes your actions potentially dangerous to somebody else, or whether you're talking about not handling a firearm properly or pushing someone with your force against when there's a table behind, all of those things are something to be litigated. But under our law, we don't have that opportunity to look at those circumstances.
Thank you, Madam Chair. We'll turn to testimony. If there's anyone in the room who is here to speak in favor of the bill, if you could please come forward.
I think there's someone else who wants to go first, and I'll let her have a little more time.
Okay. Please come forward.
My name is Susan Shoemaker. Thank you for letting me speak today in support of HB 251. My partner, Bill, was a professional engineer with the U.S. Army Corps of Engineers. In the spring of 2021, he was the victim of an unprovoked violent assault. A stranger attacked him in a Fairfax County Home Depot during the pandemic after we asked the man to pull his mask up over his nose. He responded by violently shoving Bill backwards with open hands, pushing him into metal shelving, where Bill struck his head and collapsed onto the floor, bleeding out from a gash in his skull. In seconds, he was covered with blood. Bill spent 5 days in an ICU with a fractured skull and brain bleed. The doctors were afraid he would die because they couldn't stop the bleeding. Bill was never the same. He suffered permanent injuries. His hair fell out in clumps. He had cognitive and short-term memory loss issues. He suffered depression, anxiety, and PTSD. He had personality changes and anger issues. Under current law, Bill's attacker could only be charged with a misdemeanor. At trial, he was found guilty, but he had a de novo hearing and was found not guilty in the next proceeding. That outcome crushed Bill. He never recovered. An attack that resulted in serious bodily injury, that put Bill in intensive care, that caused permanent physical harm should have been a felony. It is in other states, but it wasn't here. Virginia's malicious and unlawful wounding statute did not apply. I watched helplessly as Bill's health declined. He suffered a stroke and later died. I don't want anyone else to go through what he did. This bill will help make that happen. I respectfully ask for your support. Thank you.
Thank you for sharing your testimony, and we're deeply sorry for your loss.
Kate Hanger with the Virginia Victim Assistance Network. We support this bill.
Madam Chair, Derek Davis, Commonwealth Attorney for Surrey County, on behalf of Virginia Association of Commonwealth Attorneys. We do support this bill, and very briefly, these cases, the most common one we see is domestic violence cases where there's a domestic partner significantly larger, usually a one-punch case. A victim ends up in the hospital for weeks, broken jaw, wired shut, serious damages. That's an extremely common case we see all the time in the Commonwealth. And to prove that felony level wounding, you've got to prove an intent to maim, disfigure, or kill, and that's permanently maim, disfigure, or kill. And it's very, very difficult to prove that intent when there is one strike. So that's why we need this law. Thank you.
Thank you. And now turning to the room, if there's anyone here to speak in opposition of the bill, if you'd please come forward.
Madam Chair, Rob Bogenglass from Justice for Virginia. We do oppose the bill. I think I told this story last year, similar testimony, but there is a case, Burkeen versus Commonwealth 2013, which I had the unfortunate pleasure of arguing at the Virginia Supreme Court. I lost 7-0. It was a malicious wounding case where it was one punch, barefisted, and the Supreme Court said because the client had, the defendant had said that he could bench press 200 pounds, that one punch was enough to prove an intent to maim, disfigure, disable, or kill. It does not require that much. Our malicious wounding statute is pretty easy to get to. This bill, if it were to pass, would sort of undo the way we think about our criminal legal system. I don't say that very often, but we criminalize people based on their mental state, based on their intent, based on what they were trying to do, not on the injury that results from that. That's sort of unfortunate moral luck. And we, if we're going to start doing that, we're going to have to undo a lot of criminal laws in Virginia. So I hope we don't start down that road. Thank you.
All right, thank you for your testimony. Seeing no one else in the room, I recognize Delegate Schmidt. I see you're about, yep. I'm like reading, I know it's far away, but like I'm reading your name.
Oh, no, sorry. Thank you, Madam Chair. A question for council, I guess to follow up, to clarify a little bit, because I was trying to think of any other area in criminal law. I mean, in tort or personal injury, it's different, of course, but in criminal law, is there any area where it's based on the harm to the victim versus, as we've talked about, the intent, getting to the intent of the perpetrator?
Well, intent, it depends. I mean, there's certainly like reckless crimes where you're behaving in a way that your conduct is so reckless, you have a disregard for human life, and like involuntary manslaughter if you were so grossly reckless, but that is also an intent. Assault is a general intent crime, so it's just a touching or battery, a touching in an angry, rude, or vengeful manner. So that's a general intent. And then the specific intent crimes are the ones that I do something with malice or something like that, but I also have the intent to harm or things like that. So they're all intent-based. There's always a mens rea. There are, I can't think if there are any strict liability crimes besides maybe possession of drugs in a jail. Maybe going onto school property as a sex offender. That might be a strict liability if you didn't even know or didn't have the intent. But most crimes do have an intent element. I guess to answer your question.
Thank you. Seeing no other questions from the committee, does council have any other remarks?
No, no other remarks.
All right. I see no other questions. Chair Watts.
Again, all of the statutes that I cited are in Title 18.2. Driving while under the influence, boating while under the influence, improper handling of a firearm. And the results from those actions, if they result in serious injury or death, are punished for the results of the actions, whether or not the person who is engaged in that behavior may have intended it as they had still another whatever, but they weren't in control. The facts were litigated that they were not in control when they harmed the other person. Again, I am looking at the standard of serious bodily injury, but throughout our code, we make those gradients of the degree of harm that the person's actions produced. And that is what I'm trying to establish in this gap that we have between a simple misdemeanor and the malicious intent. And with that, I will conclude. I will conclude. Thank you. This language is different from last year's, however. It gets as narrow as possible in filling that gap.
All right, I see a question from Delegate Schmidt.
Thank you, Madam Chair. Just speaking to the bill, I appreciate the delegate bringing this, and I understand the harm that was caused in this action. I'm hesitant to shift the focus from, when we have assault, battery, these crimes that we're trying to look at, the harm goes to potentially, a whole host of other factors, but I'm really hesitant to shift away from criminal intent and mens rea when we're trying to decide the punishment, going up from a misdemeanor to a felony. So I'm sorry.
Delegate Carlson.
Hello. Speaking to the bill, yes.
You have the floor.
I don't really know any other way to talk about it because it's just so hard up here. I remember this last year. I remember the terrible feelings I had after I took the vote I did because your situation is obviously terrible and traumatic and you didn't deserve what you went through. And I'm sitting up here and I'm just hearing it and thinking, you know what, this is a year I need a vote for it. But then I cannot argue with us completely changing the way that we look at and decide what we charge people with and taking out mens rea. So I'm wondering if there might be a scenario where this can move beyond us right here today and the Crime Commission, people who can look at what other states are doing, how this all works together, can study this and give us a recommendation. And I don't know if we did that in the past, so I guess there's a question in there too. And if we did, I would love to see that study.
Madam Chair, if I may respond.
Of course, Delegate Chair Watts.
Certainly, rather than not see action taken, I so firmly believe that there is a issue to be litigated by the circumstances of whatever happened, and our law has got to allow for the litigation of those elements. And so if it's the Crime Commission that can help identify those elements that need to be litigated, because again, I'm not saying that this must be found this way. I'm saying we must have the ability to bring these issues forward in a case to have justice done in the circumstances. So if it's the Crime Commission, but I hope that their agenda will have room for it.
Thank you. I recognize Delegate Williams.
Yeah, sort of speaking to the bill. So I'm hearing what you guys are saying about like switching the intent and stuff, but I still think about like child abuse neglect cases where it's sort of like the outcome of the child is punished or aggravated. But I know what you guys are saying too, and I know this is a tough bill, so thanks for bringing it.
Chair Holt.
Madam Chair, if I could, everyone brings bills here to solve problems, and you brought a bill that's trying to solve a problem and identifying. And the question is it going too broad and in changing how we do things? And I think that we can send this to the Crime Commission. I would be willing to work with the patron, Chair Watts, on some language we can send to the Crime Commission. I want to have a conversation with them in advance to see if it's something they could take on. But maybe do a broader look and to see how other states might handle a situation like this. So I would work with the patron after session. We can put some words together to send it to the Crime Commission and to try to follow up with this and to come back next year with something that has some consensus behind it. And I won't make a motion, but if someone were to make a motion to continue the bill until 2027 with a letter to the Crime Commission or perhaps some other entity that we can make some progress and we come back next year, we'll try to find some consensus around this issue.
Madam Chair.
Delegate Hernandez.
I move that we carry the bill over to 2027 with a letter from the chair.
It's been moved and seconded to carry the bill over to 2027 with a letter from the chair to Crime Commission. That is a voice vote. All those in favor say aye. Aye. Any opposed? All right, the bill is carried over. Crime Commission will work on it. And thank you, Chair Watts.
Thank you. And I have another, and this is HB 250. And what I would ask, and I didn't bring copies of it, but if you would just bring it up online and look at the two paragraphs, the new paragraph and the paragraph before it. They're absolutely identical. The paragraph before it was put in 2008. And since 2008, localities have been able to take action to prohibit someone who is permanently barred from being next to children except his own, to keep them from, you can see all the exact same language. And the only reason I'm before you is because my jurisdiction operates under a park authority. And we had an unfortunate situation in one of our recreation areas which brought this forward. So that's all I'm asking, is that the authority that's been there since 2008 for other localities also be there for those localities who may operate with a park authority rather than the direct operation of their recreational facilities.
Thank you, Madam Chair. I see a question from Delegate Williams.
Yeah, question for the patron. So what you're saying is that currently in our parks, we have this law, but this would allow the same law to go into this Park Authorities Act.
Totally the same. It just happens to be operated differently under the local government.
All right. Any other questions? I don't see any questions from the committee, so I'll ask if there's anyone in the room who's here to speak in favor of the bill. If you could please come forward.
Thank you. Lori Sims, Legislative Deputy Director for Fairfax County. Legislation for HB 250, we definitely support this because in Fairfax County, our park authority owns, makes decisions for, and operates our parks. The locality does not. So it's just a technical administrative change that needs to be expanded. We are not asking for anything outside of what localities already have to do, but this would just put it on the same level and allow our park authority to be able to provide the same protection for those parks that they directly operate. HB 250 ensures consistency in the law and strengthens protections for our children and our families whose parks and our authorities align outside of the locality to park authority itself. So we would ask that everybody would support this. Thank you.
Thank you.
Question?
Yes, I see a few questions. I don't know if they're intended for the witness, but
No, probably the patron.
Chair Hope.
Probably the patron of the bill.
Okay.
So just a question, Chair Watts, is this exclusively for Fairfax or is it for all entities? Because I'm wondering if this would be appropriate like the county executive.
Madam
Plan
Chair,
government.
I would say to the Uber Chair that I've been meaning to absolutely look to see whether there are others. Perhaps it is known we do have a unique urban county executive form of government in the statute that isn't used by anybody else. So it may be unique to us. I don't know if anybody else has an authority.
Yes, Madam Chair, just to note that on December 6, 1950, Fairfax County Board of Supervisors created the Fairfax County Park Authority as a separate entity to make those decisions. Currently, right now, every jurisdiction or locality that we know of does have the ability to do and operate to ban sex offenders through the locality because they themselves own the park. So, however, I can get back to you on the exact numbers, but the localities that we do know of already have this and are operating in this current function. It's just Fairfax County that we know of that has this special call out.
Thank you. Delegate Schmidt.
Thank you, Madam Chair. Just a quick question. When we're talking about like the facilities owned by the Park Authorities Act, and then we have the line on 35 that they know or should know as a playground, athletic field, facility, or gymnasium. Are there other facilities that the Park Authority runs that aren't those? And are they included? I mean, I think the intent is to include those in all property that the Park Authority owns.
I would say to the Delegate Schmidt that, again, it is exact language that's been there since 2008, and we didn't want to do anything different than what has already been authorized, however that's been interpreted, et cetera. Specifically to your question, my belief is that the Fairfax County set up a park authority in part for bonding, and we have separate referendums to spend money on parks that aren't the same as the counties. I think that was part of the origin, but they're very specific. You will see there is one that has a swimming pool. You will see the designated park areas and the dog walking and the tennis courts or whatever it is that these park facilities may have. So it is as known in Fairfax County as it would be known in Charlottesville or Virginia Beach or wherever.
Delegate Williams.
Yeah, that's what I kind of picked up. Sorry, talking to Bill. That's what I kind of picked up on too, was that Parks Authority Act allowed my county to do a Parks Authority Act. If we had a Parks Authority, this would apply. But right now we do a locality. That's what it seems like to me.
Mm-hmm. It's just different structure.
Thank you. Is there anyone else in the room who was here to speak in favor of the bill? And also need to ask if there's anyone in the room who is here to speak in opposition to the bill. And Council, do you have any comments to add on this piece of legislation? See no other questions from the committee. Chair Watts, you have the final word.
Just let us do what the others are doing. Thank you.
It's been moved and seconded to report the bill. The clerk will open the roll. Acting Chair Watts votes aye, I presume.
Thank you, Madam Chairman, members of the committee.
Thank you, Madam Chair.
Thank you, Delegate Delaney. And now we have, I'm going to be nice to Delegate Williams and therefore be absolutely mean to So we have two more bills. Delegate Williams, are you ready? Sure. Or do you want Delegate Schmidt to go first?
Yeah, why don't you let him go first?
Delegate Schmidt, are you ready? Okay.
Thank you, Madam Chair, members of the committee. I think we saved a very simple one for the end of the evening. No, I'm just kidding. First and foremost, we have a substitute. I'd like to thank you.
All those in favor of the substitute, say aye. Opposed? Please proceed.
Yes. So I bring before you House Bill 1413. This is another somewhat of a cleanup bill trying to address a concern from a court case where we feel that the original intent of the law that was changed in 2021 addressing probation violations was misinterpreted by the courts, and we're seeking corrective action. I can speak a little bit to that. I will say that speaking to the substitute, I'll speak to the substitute in just a second. That's based on feedback we've received from some stakeholders. But just to lay out the very quickly, the problem summary of it, 2021 bill or during the 2021 legislative session, we tried to address the problem of technical violations in probation. So the idea of, it serves no purpose to, quote unquote, violate someone back to jail or prison based on a missed court date, a slip in drug use or testing positive, or, things that can be, corrective action can be taken by probation officers and those to try and address, knowing that people slip up, people have problems along the way of their recovery and sort of restorative justice. And so fast forward, of course, after a few years in practice, what we saw and what we've seen is some judges in some localities sort of taking advantage of what might be perceived as loopholes, or at least unclear areas of the law specifically to look at, instead of treating technical violations, say a cascading series of problems that happen because of a relapse or a missed appointment or something. For a probation violation report, there could be several instances in there of where, like, hey, you're not doing as well as you should do. Getting that to the judge, in some instances, judges were treating those as individual offenses, individual violations. And in the most extreme example that was litigated, the judge set those as different hearings in order to take them one at a time, and saying the first offense is here, then each technical infraction becomes a second offense that is potentially putting jail time or back to reassessing the sentence. The idea of the stacking those on top of each other, which was not the original intent of legislation. And so what we're hoping to do with a lot of back and forth is trying to address particularly the court case, Castillo-Canales, which was argued and litigated, that sort of, brought this to light, that, that now, because of that decision, trial judges can now take each individual infraction and turn them into separate cases. So, again, sort of stacking those. And then what that does is cause, heightened punishment when we're trying to get the corrective action on these issues. I will say that, okay, so I'll stop there. That's the general issue with the case and the problems we've had. The substitute that's before you tries to take a broader view and look at making sure that we clarify in the law the original intent of the probation. The probation change was that probation is an executive function. Probation is a function of probation officers and taking it away from sort of the full criminal judicial review and saying we're going to work in a restorative way, we're going to work towards getting these folks back into a good place. And so in proposing this bill and a lot of back and forth, thank you to the staff, we have come to a landing point with the substitute, which I can speak to any language or particular questions that you may have there. We did take some feedback, tried to respond to that feedback, but the legislative process being that no one's ever going to be happy, no one's ever going to get 100% of what they want. I think fundamentally there are always going to be some policy disputes on the purpose of probation and the purpose of our law that especially when it comes to technical violations. I think we have, of course, some folks that will speak both for and against it. And, as I said, I will answer any questions about the particularities of it. Also rely on counsel to help clarify any questions that people may have.
Are there any questions of the patron? Seeing no one requesting to speak, at this point, are there any comments from council before we take testimony? Then, if I may, anyone in the room who wishes to speak in support of 1413, please come forward so I can see how many there are. And thank you for your patience. I have one speaker, so you have 2 minutes.
All right. Thank you, Chair Watts. Everybody, I'm going to be as quick as I can. I know it's late. Thank you, Delegate Schmidt, for bringing this. Also, not just here for the Humanization Project, but also as part of the New River Valley Reentry Council. And we see this a lot where technical violations add up in a way that actually makes it counterproductive for people to reenter the way we want them to, the way that Mr. Williams, Delegate Williams' bill has encouraged already probation to be reformed. We want to use this to encourage people, and this bill will allow that to happen. And it will interrupt processes that have been misused by a few, but existing actors who are trying to get in the way of people getting off of probation. So we appreciate the patron for bringing it, and I just want to say I think this is actually going to help us in a public safety sense. Thank you.
Thank you. Is there anyone here speaking in opposition to 1413? We have 3 speakers, so 5 minutes total, please.
Madam Chair, Derek Davis, Commonwealth Attorney, Surrey County, here on behalf of Virginia Association of Commonwealth Attorneys. I think the patron did tell you about some of these things that this bill does as far as hearing all of the technical violations together. But I think what was left out in the summary is that it also expands what are considered technical violations. I also just saw that the substitute had been dropped as well, and I think that expanded even more to technical violations. And so a couple examples of some of these technical violations that would all be considered at one time. And so, for example, in my jurisdiction, it's pretty regular that we may go 3 weeks without holding a regular circuit court day. So, for example, if we had a sex offender out on probation and they were required to be on home electronic monitoring, GPS monitoring to prevent them from going somewhere, every day they could walk out of their house, go to a playground, unless the other bill passes, go wherever they want to go, and they could do that every day for 3 weeks, and then they could come back to court and nothing could happen. Another common monitoring tool we use, because it extends technical violations to monitoring, is for people with felony DUI manslaughters, 5th offense DUIs. We put them on SCRAM alcohol monitoring, which is transdermal alcohol monitoring. And we tell them, you can't drink. The reason they can't drink is because it's dangerous. They will get on the road and kill someone. But under this, if they were on probation and that was a condition, every day for 3 weeks, they could get as drunk as they want all day, and we would come back to court, and all of those would be considered one technical violation, and nothing could happen. So I think it's a very short-sighted way to look at this. Additionally, not going to your court-ordered treatment programs would be technical. And we want to get people into treatment. We want to incentivize people to go to these treatment programs. And if we can't hold them accountable to go to it, they're less likely to go to it. And I've heard a lot today about we got to trust our judges. I've heard it a lot since we've been in this committee, trust our judges. But now we don't trust our judges to make an adequate decision about probation. We should trust them to review all the circumstances and let them make an appropriate decision based on the violations. Again, I think those are some of the issues with the bill. Thank you.
Good evening, Chair Watts. Sheba Williams with No Left Turns. I obviously am on the opposite side of this and support alleviating the issues with technical violations. I am the Reentry Council Chair for District 32, and I have seen people, obviously there's a concern with safety, right? There's a concern with people doing things that are heinous, but we're talking about being late to an appointment, not being able to afford BASAP classes and things like that. There are people who are going back to jail because of their inability to pay, and what we're saying is take the most serious and also penalize people who are on a lower level. So I support the bill on the wrong side of this, what have you, but I speak in support, sorry.
Madam Chair, members of the committee, Eileen Longenecker with OES at the Supreme Court. I appreciate the conversations with Delegate Schmidt about our concerns. I think the one part of the bill that we don't have a problem is what is trying to address the Canales case about the subsequent hearings. It's the other parts of the bill that we have an issue with. We have particular concerns with the language that's been added to 19.2.265.6. Current law says that upon motion of the CA on a charge, motion of the CA to dismiss the charge, the court shall dismiss that charge. So the language being added is saying upon motion of the CA to dismiss a probation violation, the court shall dismiss the probation violation. So while we recognize that CAs present evidence of the probation violation, when the probation officer presents that probation violation to the court, sends a letter, major violation report, it's the court that decides whether to issue legal process. It's the court, not the CA, who decides whether to issue a capias or a show cause summons. And so really a probation violation is a violation of the court's order. And so we feel the court should be able to uphold its own orders, enforce its own orders, uphold the dignity of the order. And as was previously mentioned, this takes away the discretion of the courts. And we've heard tonight about how that's a good thing, leaving these decisions. And the judges who review bills for us also express concerns about the significant expansion of the technical violations, including failure to appear, the GPS monitoring, attending a specialty docket. And so we have concerns about the bill for those various reasons. Thank you.
Thank you. I see someone online for it. Brad Haywood. Brad, please proceed.
Yes, I'm here. Brad Haywood for Justice Forward. So Justice Forward, we proposed this bill in 2021. We helped draft it, and I actually argued the Castillo-Canales case in the Supreme Court of Virginia. As y'all know, 306.1 was supposed to limit the amount of time in jail a defendant would face for technical violations. Instead, now we have a ruling that allows judges who want to disregard the law it allows them to break up these one violation into as many cases as they want to get past those sentence caps. They do those hearings one after another in the courtroom. It's actually pretty absurd to watch. That not only is absurd just on its face, but it multiplies court costs for defendants. And actually, it's even against what the former procedure in probation violations was. That was never done before. In addition, now judges hold people in jail, then set hearings beyond the maximum amount of time they could receive as a way to avoid sentence caps. And lastly, to OES's point, some judges are even prosecuting these cases themselves over the wishes of the Commonwealth's attorneys. And I think the amendments to the bill now make clear that, yes, the probation office alerts the court issues process, but now once the court issues process, the prosecutor, who is responsible for enforcing all laws, including these ones, they're the ones that then get to, if they don't want to prosecute it, the court can't force them to, and the court can't act as a prosecutor in the courtroom, which is actually what's happening. That's a clear violation of separation of powers, and that the reasoning that a court must be allowed to enforce its own orders, unfortunately, is also just simply unconstitutional. The bill fixes all these problems, so we ask you to support it.
Thank you. Seeing no one else wishing to speak, are there any other questions from the committee? Is there any Delegate Williams?
Yes, Madam Chair, for the patron.
I'm sorry, forgive me, I didn't
Sorry.
look at my list and I should have. Delegate Mehta first and then Delegate Williams.
Oh, okay. Thank you, Madam Chair. I just had a quick question for council. I heard a lot of talk about expanding the definition of technical violations. Are there, just generally speaking, would this impact other parts of the code? Or is this something that could be, I guess, expanded on?
Well, technical violations came into being in the 2021 when this bill was originally passed, because I think we were seeing disparity in what certain courts were sentencing people to on probation violations. Like, I know there was a case out of Pulaski where the guy got 7 years for testing positive for marijuana. And, then some people are getting a program or no time. So that was created by the General Assembly. And then what we've seen, which I guess is why the expansion, is certain judges will find things as technical violations because how they come in a probation report, if they're one of the rules of probation, right? One of them is be truthful, cooperative, comply with your probation officer's instructions, report as instructed. So a lot of times that will be a technical violation, but it could be all of these things. And then some judges are finding that those are special condition violations. And then the courts are kind of trying to decipher whether something was specifically ordered by the court and that would be a special condition, or whether it's a technical violation and it's encompassed by that number, I think it's number 5, that it's like report as instructed, be truthful, cooperative, and that's a technical, but then the courts have been divided. So the goal of including this language was to kind of sort out for the courts what would be a technical is, I guess, the intent of the legislature. So that's what we've kind of seen in practice. It depends on the judge you're in front of. It depends on, honestly, the probation officer. Sometimes they're checking it as a technical condition 5, I think it is, and I could be wrong. And sometimes they're checking it as a special, and that would change the guidelines and then also the statutory range, if that makes sense.
If I could ask a follow-up question on your response. So we heard that shall was used repeatedly in the language. So how does that sort it out for the judge? Is it directing the judge, or is it grouping the types of situations that he needs to respond to? Again, shall does not sound like it's just sorting it out.
Right. So when the General Assembly passed this statute in 2021, the shall, and this has been interpreted by the courts, if it's a first technical, you cannot get jail time, shall. You're not allowed to be sentenced to jail time no matter how much time is over your head. Second technical, up to 14 days, but there's a presumption that there shouldn't be jail time, but the prosecutor can overcome that. Third technical, all bets are off, all time over your head the judge can give. So shall does mean shall, and that has made some judges angry because, as OES pointed out, probation violations are probation is order of the court, and they've seen this as the legislature infringing, but the legislature can put caps on sentences, and that's what has happened. So this expands the technicals or makes it clearer, and then lays out for the court that they can't piecemeal multiple hearings. So a lot of times probation will give people a chance. Like, they might test positive 5 times before they issue a violation. And what the intent, my understanding of the General Assembly, was that that would be heard in one hearing, it'd be one technical. But in this case, basically it was an 8-month period. There were some missed appointments, some missed drug tests, and some positive screens. And the judge chose to take those as 3 different hearings. And that way it was a first technical, a second technical, up to 14 days, and then I think he got 42 total days. And then the Court of Appeals was like, that was correct, and then the Supreme Court was like, actually, it was only 2, so we'll make it 2, or, I mean, Mr. Haywood could probably correct me if I'm wrong, but that's my reading of it. So this was to clarify, if it's one violation, it's one report, it should be one revocation hearing, not tacking on multiple in the course of a probationary period.
Thank you. Delegate Williams?
Yeah, speaking to the bill, Delegate Davis next to me said, yeah, they shouldn't be doing that when you talked about the multiple hearings. And I had a retired judge say to one of the defendants that the public defender had was, I think I'm going to continue this case and think about it for about 6 months. And then he said, if you want to appeal it to the Court of Appeals, feel free. But it was basically a threat to say, you're going to sit in there for 6 months. So yeah, I agree that you should pack them all together and stack them, but I don't love the expansion because it does say things like a technical violation is failing to comply with any condition of court order, probation, treatment, rehab, recovery court, that kind of thing. So I'm not in favor of the expansion, but I definitely think the stacking issue is needed to be addressed.
Seeing anyone else wishing to speak? I think we're at the point where you get the final word.
Yeah, thank you, Madam Chair, members of the committee. I appreciate the feedback, and I think when we were adding in some of the technical violations, we were having a little trouble figuring out how to again going to that intent element of like we don't want trip ups to result in going back and being punitive. But we realize that it's hard to thread that needle to say, obviously, how to address the more severity. We're not trying to also give loopholes for intentional behavior. It's a little hard to get to both to say, if someone is intentionally violating their probation multiple times, we're not trying to give them, cover for bad behavior. We're trying to address the slip-ups. And so if we've reached consensus on that, great, but we definitely are still taking feedback on this issue and want to make sure that we're only halfway through. We have more workshopping to do.
I'm trying to puzzle through what I think I just heard halfway there. You have something that you think it's important to go through now to move forward on in clarity, and we carry over the rest, or we carry over the whole? I'm sorry, please speak, please address.
Thanks, Madam Chair. I would move to report as substituted and then allow the patron to continue to work on some language between maybe now and full, especially with the Office of the Executive Secretary who mentioned some concerns. So that would be my motion.
Yeah, I think also we have the Senate is going to obviously weigh in with their concerns.
Yes, they are.
I look forward to fielding their concerns.
It's not going to be pretty. Go ahead. Then what motion is in order?
Second. She moved to report. Second. With substitute.
The motion has been made to report with substitute. Any further comment? Please open the roll. Members, cast your vote.
Oh, yeah.
I'm assuming that with Delegate Schmidt's vote, it is now 7-3. It reports with substitute. Final bill before us is Delegate Williams.
You just pass that down there.
Delegate Williams has House Bill 208 for the handout.
Thank you.
All right. Madam Chair and committee, you can stop looking at your bill in front of you. I have a substitute that I'm not even going to introduce because this bill is not ready for prime time. Once I'm done with this little presentation, I'm going to ask you to strike it. But what I want to talk about is this particular issue that I've come across in my practice heavily in the juvenile and domestic relations fields, domestic violence fields, that kind of thing. So if you weren't aware, Virginia doesn't have a true restraining order like you would think about in, a 500 feet away from me type of order. We do have protective orders, but they have a really high burden threshold. I think you guys know that. You have to show violence, force, or threat of bodily injury. And sometimes this standard is so high that victims of domestic abuse and violence, they will have a hard time actually taking the initiative to go get a protective order, because you could think about what would happen if that didn't go well. And so there's a concern about them coming forward. I think that there's a gap in Virginia law. So you can get a no trespass sign for your property, and you can also send somebody a no trespass letter, but it's only good for your property and your work property. But now we live in a world where like communication is everywhere. Like you can get to me through my PlayStation and stream and just whatever kind of technology we have. And I think that our bills, we're always trying to bring them up to speed. And I think that this particular code section still lives in a world where we had U.S. mail, phone, and fax. And so one of the things that I am hearing a lot is I want the person to leave me alone. But you're not, the person who is doing the harassment or the person who will not leave the other person alone is walking right up to the criminal line of stalking and then never crossing it. Or it's hard to get evidence that they're stalking, but they're doing petty things like calling your work, texting, 3 or 4 friends on your social media, that kind of thing. So they just won't leave you alone. And so what I hear a lot when I'm doing these protective order hearings, which is the highest burden, I hear one side be like, I don't want anything to do with the other person, but I don't want to lose my gun rights, is a big thing that the respondents always hear. And so they fight it a lot. And then from the petitioner's side, I will hear, I'm not scared of him, I just want him to leave me alone. Or I've even heard, I don't want him to lose his gun rights because he likes hunting, but I just want him to leave me alone. And so I've gone into court multiple times and said, I understand that, but he doesn't want to lose his gun rights. She don't want to give it up. The judge has actually put in no contact orders for me, but that's not an actual vehicle right now. So the point of this is to try to fill a gap as carefully as I can. And the thought was, if I can lower the burden of a protective order but give more coverage than a non-trespass or no trespass. And the concern, and why I gave you guys the little handout, is because it sort of says current law, and then the right side was sort of my goals, like what I was trying to go for. So you guys can look at that whenever you want, but it does try to take care of a lot of different elements that we deal with a lot in our other laws, like affidavit for swearing it out. Like, for instance, the protective order, you would go in front of a magistrate, get an emergency one. This idea was you could go and get one in front of a judge. I know that OES is here, and I know that they were concerned about what it would take to pull this off. And we've talked about it multiple times, and they're happy to try to help me with this too. But I think I'm just asking the crime subcommittee to hear me out on this and sort of think about it with us, so I could possibly do something next year. I don't know what the answer is, so I'm leaning on Uber Chair Hope to give me some guidance on that. But I do think that this is something worth
approaching. It is very common in a lot of other states. And the goal here for me would be if the two people were in front of a judge and the judge could say, you need to leave that person alone. Because I think that's what those type of people need, is some authoritative figure to say, if you don't do it, you're going to be in trouble. And so that's what this is trying to attack. It doesn't do it quite right yet. This is the first time I've run it. I've been thinking about it for a while, but I appreciate you guys listening, and maybe you can help me fix it later.
Thank you very much. And I assume at the proper time there will be a motion, but I'm going to say I love a good chart. I love all the groupings that you have done as you have tried to focus on what are the elements. So you've done very good work, and it's a good way to have our last meeting before crossover conclude as far as the good work that House members can do, as we're about to go over on the other side of the chamber. So is there a motion that you would like made at this time? Or okay, we move to strike. Is that a recorded?
To strike, yeah.
No, see, if I strike it, Carlson can carry it next year, and I don't have to.
Strike from the docket is a recorded vote. We could just pass it by if you don't want us to.
Strike.
Okay, here we go. All those in favor of striking it, please open the roll. All those in favor of striking, please cast your vote. At the request of the patron.
I get a non-suit.
It has been stricken from the docket as requested.
Thank you, guys.
No, it's just.
Okay.
Further business before, we were just asked about Hamilton's bill as chair. He was not here, therefore we have heard it and no action is taken. It doesn't exist. Crossover will happen, and that's it. So, having said all that, move to adjourn. Adjourned.
Good job.